Recording in progress.
Cek mic nomor 4. Cek mic.
Distinguished ladies and gentlemen, for the one that's located at the foyer or still conducting the registration, we would like to invite you to join us in the Istana Ballroom, and please kindly be seated. Bapak Ibu sekalian, kami ingin mengundang bagi para peserta, delegasi dan juga partisipan yang masih ada di area foyer, kami mohon kesediaannya untuk segera bergabung di Istana Ballroom. Ladies and gentlemen, we would like to ask for your keenness to kindly be seated. We still have a lot of empty chair, and please kindly move to front area of the table as well and place yourself in the empty chair. We still have several table that still have a lot of chair empty. Bapak Ibu sekalian, kami mohon kesediaannya untuk menempati kursi yang masih kosong. Posisinya ada di depan, di dekat panggung. Kami minta kesediaannya untuk menempati kursi yang masih kosong dan agak maju ke depan. Terima kasih. Semua udah masuk. Distinguished guests, ladies and gentlemen, good morning. Welcome to Saripan Pacific Hotel Jakarta, Indonesia. Before we start our sessions, we would like to inform you the safety briefing protocols. We would like to invite the Chief Security of Saripan Pacific Hotel Jakarta to present the safety briefing protocols. Pak Irfan, silakan.
Okay. Good morning, ladies and gentlemen. How are you today? Welcome to Hotel Sari Pacific Jakarta Autograph Collection. My name Irfan, in charge for the security. This morning, I will conduct for the safety briefing, but shortly. First time is you all in the ballroom area on the fourth floor. Exactly at the ballroom. In this room, we protect using the smoke detector, public announcement, and also the fire extinguisher. In this hotel also, we made for the heat or emergency hotel action team. In case of the emergency, we are the first person to check. In case of the fire, please, for all of you, welcome. Okay, in case of the fire, please don't panic because we had the heat team will be check the condition, and also in this situation, sometimes we feel the earthquake. So the earthquake procedure, please don't panic. My team will be give you direction to go to the assembly point. And the point is today we don't have any plan for the fire drill. So in case of the ring for the alarm, please don't panic, just follow our instruction. I think that's all from us. Thank you very much. Enjoy your day. Good morning.
Thank you very much, Mr. Irfan, the Chief Security of Saripan Pacific Hotel, Jakarta, Indonesia, for the safety briefing protocol. Distinguished guests, ladies and gentlemen, please kindly welcome all the honorable guests has arriving at the venue. Good morning, ladies and gentlemen. Assalamualaikum warahmatullahi wabarakatuh. Shalom. Nama budaya, Om Swastiastu. Salam kebajikan. My name is Melati Dewi. I'm going to be your MC for the forum. Welcome to the first day of Asia Pacific Justice Forum Building Partnership for the Rule of Law. Without further ado, the first day highlighting the themes, scoping the justice challenges in Asia Pacific. We would like to ask the keynote of Elizabeth Anderson as the Executive Director of the World Justice Project to deliver the opening remarks. Ms. Elizabeth Anderson, the time is yours.
Good morning, Excellencies, ladies and gentlemen. Welcome to the Asia Pacific Justice Forum. My name is Elizabeth Anderson, and I am the Executive Director of the World Justice Project, and it's a great pleasure to welcome you here on behalf of the World Justice Project and our key partners in this convening today, the Australian government, the Australia-Indonesian Justice Partnership, Kemitraan, and the Ministry of Law of Singapore. We're incredibly grateful to these partners for supporting this convening, and also for other sponsors who have helped make this possible, the Hong Kong Bar Association, LexisNexis, and Jupitus, as well as members of the WJP Private Sector Partnership for the Rule of Law. For those of you not familiar with the World Justice Project, we are an independent, multidisciplinary research organization working to advance the rule of law worldwide. We have offices in Washington, D.C., Seattle, Mexico City, and Singapore. Our mission is to create knowledge, build awareness, and stimulate action to strengthen the rule of law. We do this with an aim of building a world of rule of law communities, delivering justice, opportunity, and peace. Because we believe that the rule of law is foundational to so much else that we seek: economic development, accountable government, respect for fundamental rights, and prosperity. Traditionally, the rule of law has been considered a matter for lawyers and judges, but we believe very keenly that the rule of law is something for all of us to work on. And so we seek partnership with many different professions and disciplines, everyone in society, whether they be doctors or business people, police, military, people in the arts, engineers. All of us have something to do to build a rule of law culture. WJP takes a data and evidence-based approach to advancing the rule of law, and you'll hear about our Rule of Law Index later this morning. And another key principle is collaboration with partners around the world to develop the rule of law, and that's why today's convening is so important. We come together with three objectives. First, we are concerned about the global rule of law trends, declining in a majority of countries for the 5th year in a row, and particularly the worsening trend that we see in rule of law in the Asia-Pacific region, where 71% of countries that we evaluated this year saw a declining rule of law. We want to share this data with all of you and draw on the expertise in this room to understand the trends and together to identify solutions. Second, against the backdrop of those broad trends, we want to focus attention on three particular issues that we see in our data and that we have heard about from our colleagues across the Asia-Pacific. These three issues are reflected in our agenda these 2 days, and they are the deterioration of judicial independence. This is a result of a global rise in authoritarianism, and we have seen the same trends and patterns in the Asia-Pacific, where executives have increasingly threatened the independence of judiciaries. The second issue is access to justice for minorities. Against a backdrop of high inequality among people with diverse cultural and social backgrounds in the region, access to justice remains a significant challenge that we want to explore with all of you. The third topic is disinformation and the laws that have been adopted to address this challenge to all of our societies. We are concerned that increasingly, instead of addressing disinformation, some of these laws have curbed important rights of free media and expression and contributed to a closing of space for civil society. These three threats are now the core of WJP's strategy for this region and this forum these 2 days. Finally, as I mentioned, a core focus of our approach is to work in collaboration with others and to find solutions. And that's very much what we hope to do these next 2 days. To hear from partners from a diversity of perspectives about their views of these issues. We want to hear from governments and companies, academics and the media, and civil society organizations, and specifically to identify what is working and share that learning with all of you. So I'm delighted to open these events today and look forward to a very rich 2 days of discussion. Thank you for being here.
Thank you very much, Mrs. Elizabeth Anderson, for the wonderful opening remarks. Distinguished guests, ladies and gentlemen, the next will be the keynote statement. We would like to invite the keynote of Honorable Muhammad Sharifuddin, Chief Justice of Supreme Court of Indonesia, to deliver the keynote statement. Kami persilakan Bapak.
Yang terhormat, pelapor khusus Perserikatan Bangsa-Bangsa tentang independensi hakim dan advokat. Yang terhormat, Wakil Menteri Hukum dan HAM. Yang terhormat, pimpinan Komisi Judicial, pimpinan Komnas HAM, dan perwakilan kementerian dan lembaga negara yang tidak dapat saya sebutkan satu persatu. Yang saya muliakan rekan-rekan saya dari Mahkamah Agung, hadir Wakil Ketua Mahkamah Agung yudisial dan non-yudisial, serta Ketua Kamar Pembinaan Mahkamah Agung. Yang terhormat pimpinan World Justice Project, Australia, Indonesia, Partnership for Justice 2, dan Kemitraan, serta Bapak, Ibu, para kolega dan tamu undangan yang saya hormati. Assalamualaikum warahmatullahi wabarakatuh. Selamat pagi, salam sejahtera untuk kita semua. Om Swastiastu, Namo Buddhaya, salam kebajikan. Selamat datang di Jakarta, para peserta sekalian. Adalah suatu kehormatan bagi saya untuk memberikan pidato kunci dalam acara Asia Pacific Justice Forum dan berada di hadapan Bapak dan Ibu yang hadir mewakili lembaga peradilan, lembaga pemerintah, akademisi, sektor swasta, para jurnalis, dan organisasi masyarakat sipil dari berbagai negara. Sebelum memulai pidato, secara khusus saya ingin menyampaikan penghargaan dan terima kasih atas dedikasi dan komitmen dari World Justice Project yang telah mempromosikan arti penting penegakan rule of law ke seluruh dunia. Indeks Rule of Law yang disusun WJP bersama dengan Global Performance Indicator lainnya telah menjadi kompas bagi Mahkamah Agung dalam upaya untuk memperkuat supremasi hukum yang merupakan prasyarat negara demokrasi dan jaminan pemenuhan hak asasi manusia. Salah satu tema penting dalam diskusi pada forum ini adalah independensi peradilan. Tanpa adanya independensi peradilan, maka negara hukum atau rule of law tidak mungkin dapat diwujudkan. Untuk itu, pada kesempatan ini, saya ingin berbagi pengalaman Mahkamah Agung dalam menghadapi tantangan dan mengambil peluang untuk mewujudkan independensi peradilan. Tiap-tiap lembaga peradilan di dunia memiliki sejarah dan perjuangannya sendiri untuk mewujudkan independensi peradilan. Peradilan di Indonesia memiliki sejarah panjang mewujudkan independensi peradilan. Salah satu langkah yang ditempuh Indonesia untuk mewujudkan independensi institusional adalah dengan menerapkan sistem satu atap pada tahun 2004. Dengan diterapkannya sistem ini, kewenangan administrasi, organisasi, dan finansial yang sebelumnya ada di tangan pemerintah dialihkan kepada Mahkamah Agung. Konsep pengelolaan badan peradilan menurut sistem satu atap ini menempatkan Mahkamah Agung bukan hanya berfungsi sebagai pengadilan tertinggi di Indonesia, tetapi juga bertanggung jawab atas pembinaan personil, pengelolaan keuangan, dan penyediaan fasilitas pengadilan di seluruh Indonesia. Sistem satu atap mungkin bukan sebuah sistem yang mudah dicari padananya di dunia. Sistem ini dibangun sebagai respon atas konteks historis dan politik Indonesia yang dalam perjalanannya telah berdampak positif dalam memperkuat independensi peradilan dari pengaruh dan tekanan lembaga lain. Hadirin sekalian yang berbahagia, pelaksanaan sistem satu atap bukanlah tanpa tantangan. Indonesia merupakan sebuah negara besar dengan lebih dari 276 juta penduduk yang mendiami wilayah kepulauan yang sangat luas, yang terdiri dari 17.000 pulau besar dan kecil. Akses keadilan merupakan permasalahan nyata. Kondisi geografis dan beragamnya penduduk dari berbagai latar belakang, suku, budaya, agama, bahasa, serta berbagai lapisan sosial juga menciptakan tantangan untuk pemenuhan akses keadilan, untuk memberikan pelayanan keadilan bagi seluruh masyarakat. Pada saat ini terdapat lebih dari 900 kantor pengadilan, lebih dari 8.000 hakim, dan 32.000 pegawai pengadilan di seluruh Indonesia. Mengelola organisasi peradilan yang sebesar ini tentu bukanlah perkara yang mudah bagi Mahkamah Agung. Revolusi industri dan transformasi teknologi yang terjadi di seluruh dunia menjadi peluang yang digunakan oleh Mahkamah Agung untuk merespon tantangan berat tersebut. Modernisasi pengadilan dengan menggunakan teknologi informasi kami pandang sebagai cara terbaik untuk mendekatkan masyarakat kepada pengadilan, mendorong keterbukaan, dan meningkatkan efisiensi pelayanan pengadilan dari sisi waktu maupun biaya. Hingga kini, Mahkamah Agung telah mempublikasikan lebih dari 7 juta putusan melalui direktori putusan, dengan rata-rata 80.000 putusan diunggah setiap bulannya. Pada tahun 2012, Mahkamah Agung juga memperkenalkan sistem penelusuran perkara yang membuat proses administrasi perkara di pengadilan tersedia secara online dan informasinya bisa diakses para pihak secara real time. Sistem ini tersedia di seluruh pengadilan di Indonesia, membuat masyarakat dapat dengan mudah mendapatkan informasi utuh tentang perjalanan kasus mereka sejak didaftarkan hingga selesai. Munculnya pandemi COVID-19 justru menjadi peluang untuk mengakselerasi transformasi dari pengadilan konvensional ke pengadilan modern. Pada tahun 2018-2021, Mahkamah Agung mempersiapkan dan meluncurkan e-court dan e-litigation yang mengubah administrasi peradilan pidana dan perdata menuju sistem digital. Sistem ini memungkinkan masyarakat untuk mengajukan gugatan di bidang perdata, perdata agama, dan tata usaha negara secara elektronik dari mana saja ke pengadilan yang berwenang. Para pihak yang mungkin berada di lokasi yang jauh dan terpencil tidak perlu mengunjungi gedung pengadilan secara langsung, sehingga proses berperkara menjadi jauh lebih cepat, sederhana, dan ringan biayanya. Hadirin sekalian yang berbahagia, terlepas dari berbagai kemajuan yang terus diupayakan oleh Mahkamah Agung, independensi peradilan masih terus menjadi tantangan keseharian bagi hakim dan pengadilan di berbagai tempat di Indonesia. Hakim masih terus berhadapan dengan upaya intervensi terhadap independensi individual maupun independensi ekstra institusional yang muncul karena berbagai pengaruh dari luar. Oleh karenanya, Mahkamah Agung menyadari perlunya terus menjaga integritas dan kemandirian hakim. Hakim di Indonesia pada saat ini bisa dikatakan sebagai profesi yang paling banyak diawasi, baik oleh badan pengawasan yang dibentuk oleh Mahkamah Agung sendiri maupun oleh Komisi Judicial sebagai lembaga pengawas eksternal yang independen. Namun demikian, upaya membangun budaya organisasi yang berintegritas dan memberantas korupsi pada lembaga penegak hukum, termasuk pengadilan, tidak dapat ditempuh hanya melalui pengawasan. Diperlukan upaya reformasi kelembagaan yang sistemik dan berkelanjutan, yang dampaknya akan dirasakan secara gradual. Pengadilan modern, transparan, berbasis teknologi informasi, juga merupakan salah satu upaya Mahkamah Agung untuk memperkecil peluang korupsi. Dengan cara membangun keterbukaan, dan memperkuat akuntabilitas pelayanan pengadilan. Bapak Ibu hadirin yang saya hormati. Pada kesempatan ini, sesuai dengan topik forum yang diangkat oleh WJP, saya ingin menggarisbawahi bahwa independensi peradilan juga harus diartikan sebagai jaminan terhadap kebebasan, penghargaan terhadap HAM, dan penegakan hukum secara imparsial. Mahkamah Agung menyadari bahwa kepuasan masyarakat terhadap kualitas dan konsistensi putusan di setiap tingkatan pengadilan masih perlu menjadi perhatian dan menjadi prioritas kami. Di tengah-tengah kekhawatiran masyarakat terhadap menyempitnya ruang atas kebebasan berekspresi, saya ingin menyuruhkan kepada para hakim agar semakin peka terhadap dimensi HAM dalam perkara-perkara yang masuk ke pengadilan. Jaminan pelindungan HAM dalam konstitusi kita, Undang-Undang Dasar Negara Republik Indonesia tahun 1945, Undang-Undang Hak Asasi Manusia, serta berbagai konvensi internasional yang telah diratifikasi Indonesia, menuntut para hakim di semua tingkatan peradilan di Indonesia untuk selalu merujuk dan mempergunakan berbagai ketentuan ini bersama-sama dengan ketentuan pidana yang berlaku. Hanya melalui putusan-putusan yang berkualitas, yang memiliki pertimbangan hukum yang komprehensif, maka fungsi pengadilan sebagai pelindung hak asasi manusia dalam konsep rule of law dapat kita wujudkan. Hadirin sekalian yang berbahagia. Tema konferensi kita dalam 2 hari ke depan adalah Building Partnership for the Rule of Law. Saya mendapat dan meyakini pesan dalam tema ini bahwa perubahan tidak dapat dilakukan sendiri. Reformasi hukum tidak dapat dilakukan tanpa dukungan dari pembuat undang-undang, baik pemerintah maupun DPR. Sumbangan pengetahuan hukum dari para akademisi, kontribusi dan partisipasi dari organisasi masyarakat sipil, serta mitra pembangunan dari berbagai negara, serta iklim ekonomi yang kondusif dari sektor swasta dan pasar. Mahkamah Agung telah merasakan sendiri buah dari keterbukaan dan partisipasi publik dalam reformasi peradilan. Reformasi peradilan yang terus berkelanjutan tidak mungkin terjadi tanpa dukungan dan kontribusi konkret organisasi masyarakat sipil, akademisi, dan mitra pembangunan. Saya berharap kemitraan yang kuat dengan elemen masyarakat sipil dapat menjadi suatu pelajaran yang dapat diambil dari proses perubahan di Mahkamah Agung Indonesia untuk reformasi hukum di negara-negara sahabat di kawasan Asia Pasifik. Demikian, akhirnya harapan saya adalah dapat menghadiri lagi forum-forum ini atau forum WIJP lainnya dengan kondisi menguatnya rule of law di negara kita masing-masing. Demikian, terima kasih. Wabillahi taufiq wal hidayah. Assalamualaikum warahmatullahi wabarakatuh.
Waalaikumsalam warahmatullahi wabarakatuh. Thank you very much, Honorable Muhammad Syarifuddin. Distinguished guests, ladies and gentlemen, we would like to inform you that we provide simultaneous interpretation system equipment. I would like to inform you, if you would like to listen to the English interpretations, please kindly select channel 8. If you would like to listen to Bahasa Indonesia interpretations, please kindly select channel 4. Without further delay, we would like to proceed to the next keynote statement. We would like to invite the keynote of Deputy Minister Edward Omar Sharif Hiarish, Deputy Minister of Law and Human Rights of Indonesia.
Honorable Chief Justice of Supreme Court of Indonesia, Professor Syarifuddin, United Nations Special Reporter on Independence of Judges and Lawyers, Professor Margaret, Executive Director of the World Justice Project, Elizabeth Anderson, all of interment and audience. Assalamualaikum warahmatullahi wabarakatuh. Om Swastiastu, Shalom, Namo Buddhaya. The social structure of today represents a society that is dynamic and undergoing rapid change. Transnational networks are becoming more prevalent in trade, global banking, and industry. There is also the transfer of accountability for the general welfare of citizens to the individual themselves, including for things like job benefit, healthcare, retirement, education, and housing. Many growing economies, including our own, are experiencing these interconnected trends. Many studies convey that we are currently observing a shift away from social inclusion policy that encourage participation and reciprocal recognition to ones that emphasize culture assimilation, social exclusion, and political neutralization. In this sense, the three issues of assimilation, exclusion, and neutralization serve as the cornerstones for emerging social control mechanisms. These mechanisms are used in conjunction with an expanding surveillance apparatus and are ultimately motivated by the belief that the risks posed by various threats can be estimated and avoided. Our current challenges in pursuing legal justice should be framed within this backdrop. First, the importance of judicial role in democracy. The judicial role as a concept combines two functions: third-party merit-based dispute resolution and social normative governance. In the first sense, rational, reasoned, and public dispute resolution by courts allow for determination that can be accepted by the loser. Each party is given an equal opportunity to present their case. They are aware that the judge is subject to internal discipline, such as providing a reason for the outcome and maintaining professional self-respect. In Indonesia, judges face the external discipline of the availability of appeal and potential criticism of their reasoning within the legal system and wider legal culture. At the same time, such court-mediated dispute resolution promotes three elements. First, predictability of law is achieved through clarification of substantive content of law in the act of applying it in specific cases. Second is for law and legal practice, especially in balancing public's right for information and individual integrity. In Indonesia legal practice, human rights norms have been integrated in legal reasoning with a great effort. As an example, in 2019, the Administrative Court reviewed the government internet shutdown decree in Papua. The court delineated three limits tests. The first, whether or not one of the aims is to guarantee recognition and respect for the right or good name of other party, or to fulfill just demand based on consideration of morality, religious values, security, decency, public order, or public health in democratic society. Second, the jurisdiction must be based on law. And the last, it must be proven that the restriction is legally necessary, proportional. Important to note at this point that navigating the three tests imply a wide range of spectrum to consider. Thus, it is not binary and simple yes or no question. The last issue is related to access to justice for minorities. The terminology of minority in Indonesia is rather theoretical than legal. In this sense, our legal system does not consider certain groups are less than others, either in quality or quantity. Our legal system, however, promotes emancipatory policy for vulnerable groups, for instance, child, women, other communities, and elderly people. Relevant to this, it has been one of our long-standing policy that the governments, both the central and the local, provide legal aid fund across the country. Poor and vulnerable groups have been the target of this policy. This year alone, the Ministry of Law and Human Rights have spent 36 billion rupiah dedicated for almost 10,000 cases. Admittedly, there is still a lot of work to be done to address real-life legal problems faced by public at large, especially the vulnerable ones. Thus, the three issues are but a drop in the vast ocean of effort to achieve justice and welfare. In today's late modernity, all elements, public and private, national and international, government and civil society must collaborate and form a strong partnership. As modern society becomes more fluid, we hope to establish law as the society's strong and firm foundation. Thank you very much for your attention.
Thank you very much, Deputy Minister Edward Omar Sharif Yarich. Distinguished guests, ladies and gentlemen, the next keynote statement will be delivered by Professor Margaret Satterthwaite, UN Special Rapporteur on the Independences of Judges and Lawyers. Professor Margaret already joined us online and would like to deliver the keynote statement.
Good morning. Thank you. Good morning, Honorable Chief Justice, Deputy Minister, Excellencies, and distinguished colleagues. Salamat pagi. It's a true honor to address you today as the UN Special Rapporteur on the Independence of Judges and Lawyers at this important gathering, the inaugural Asia-Pacific Justice Forum. I want to thank the World Justice Project for the invitation to speak with you. In the past decade, the World Justice Project has become a trusted source of data and analysis concerning access to justice around the world, and I'm grateful for all that they do. It's exciting to know that representatives of government, the private sector, intergovernmental organizations, the academy, and civil society from across Asia are gathered in Jakarta for this event. I would much rather be with you in person, not only because I would be speaking to you at 9 a.m. instead of 9 p.m., and not only because I love the city of Jakarta, but also because human connections are at the heart of justice, and sitting with colleagues is crucially important to collaborative endeavors. However, as we all learned during these COVID years, technology gives us a very decent second option. And so my main message to you is this. Today, independent judges, lawyers, and grassroots justice advocates are on the front lines of the rule of law and human rights. Judges play the crucial role of checking executive overreach, protecting against corruption, and upholding core human rights, including freedom of speech and assembly, physical integrity and due process, and the rights of marginalized communities. For these reasons, an independent judiciary is essential. We in the human rights field know this, and we intend to stand beside judges, civil society organizations, academics, and others who speak out in favor of a judiciary that is independent and acts with the highest integrity. As you know all too well, the recent years have been challenging. The climate emergency, a global pandemic, rising authoritarianism, high inequality, and rapidly escalating costs of living across the world. These and other factors have contributed to significant suffering and widespread human rights abuses. Many crucial issues related to these crises have come before national courts, and judges in all regions have had to grapple with unprecedented legal and factual questions, often without the resources or time they need. In this context, independent judges have never been more important. And to the shame sometimes of the global community, the very independence, competence, and wisdom these judges bring to their work is sometimes the thing that puts them in danger. Democratic backsliding and rising authoritarianism are compromising the integrity of legal systems and creating grave risks for judges and lawyers. Powerful actors with a strong interest in capturing and weakening systems that would otherwise provide a check on power are adopting a range of tactics. This playbook includes overt threats and intimidation, removal from office, criminalization, and attempts to pay for silence. But the playbook also includes stealth attacks on judicial independence, such as the transfer of independent judges to courts far from their families, amendments to laws and regulations concerning judicial retirement, pensions, and salaries, all in efforts to quiet opposition to creeping authoritarian tendencies. Another trend that is very concerning was recently highlighted by the UN Working Group on Business and Human Rights, which found that companies sometimes use courts, quote, as avenues either to silence criticism or to influence political outcomes, end of quote, by bringing so-called SLAP suits, strategic lawsuits against public participation, that aim to intimidate and burden critics of a company in order to silence them and others who might speak up. The situation is very concerning. Judges are asked to spend time on abusive lawsuits when lawyers and paralegals face possible penalties for the simple act of defending the environment, indigenous communities, or human rights defenders. Stepping back for a moment, let's think about why independent judges are so important, even in settings where autocratization is not underway. An independent judiciary is vital to the protection of all human rights. It's absolutely essential to resisting undue influence, ensuring equality, and providing remedies for justice problems. It's easy to understand why judicial independence is important when you think about the forces that could make a judge unfair. Imagine a judge who is required to pledge loyalty to a leader to get their position. Imagine a judge who's not paid a decent salary and becomes vulnerable to bribes. Or think about judges who harbor discriminatory attitudes towards some populations or believe women are inferior. Would you want to bring your case before this judge? No one would. And yet, for some, this is not unusual. Guarantees of judicial independence and integrity, structural, legal, and individual, are all important for ensuring that all people, no matter their station or their situation, can get a fair hearing. And these fair hearings are important when human rights are on the line. According to the World Justice Project, 2022 is the 5th year in a row that the rule of law has declined in most countries, and respect for core human rights and freedoms are falling in 2/3 of the countries this year alone. Regionally, WJP data demonstrates the same decline in in constraints on government powers in Asia over the past several years. The latest Varieties of Democracy report notes that, quote, the democratic decline is especially evident in Asia Pacific, where the degree of liberal democracy enjoyed by citizens is down to levels last seen in 1986, some 35 years ago. As the Special Rapporteur on the independence of judges and lawyers, I have a unique opportunity to cooperate with rights holders, civil society, UN member states, and other rule of law allies to ensure that our legal institutions and justice systems are really fit for purpose that they can support the realization of human rights for all. The mandate is also uniquely positioned to monitor and respond to some of the threats to judges that we've discussed this morning. I plan to respond as those threats occur, but also to connect disparate cases, identify systemic abuses, and name important regional and global trends. Cooperation with civil society, the academy, and member states is crucial to this endeavor. I'm eager to amplify the lessons not only that lawyers and judges have for those of us trying to protect the rule of law, but also to amplify the lessons that grassroots justice advocates have for other justice operators. Those who are excluded from the protection of legal systems have often overlooked insights and knowledge for those running the systems. By listening to those bearing the brunt of injustice, we can focus on the things that need to change. In closing, I invite you to reflect on your role in upholding judicial independence. Decaying norms and the slow degradation of legal systems are sometimes hard to discern. Laws are adopted, executives reach further, judges come under pressure. And this is where you come in. I encourage you to lift your voices in support of an independent judicial system in which judges of diverse backgrounds and life experience can serve with integrity and in security. Thank you very much. Terima kasih.
Thank you very much, Professor Margaret Satterthwaite, for the wonderful keynote statement. Ladies and gentlemen, that will be our opening remarks and all keynote statement. We're going to proceed to the next sessions, which is Regional Asia Pacific launch of the 2022 WJP Rule of Law Index. Presentations of the research finding of the 2022 Rule of Law Index will be delivered by Alejandro Ponce, Chief Research Officer, World Justice Project. We would like to ask for your keenness. Alejandro, the stage is yours.
All right. Well, thank you very much. It's an honor to be here. I'm going to present today the results of the Rule of Law Index 2022. I'm going to show you first the global results and then the results for the Asia Pacific region. If someone can put the presentation up there, please. Thank you. Next slide. So first off, let me tell you what the Rule of Law Index is about. So the Rule of Law Index is a quantitative tool to measure adherence to the rule of law in practice. By rule of law, we have a definition that we can summarize in these 8 factors that essentially measure the constraints in practice that the law and the legal system may impose on authorities on what the, on one hand, or on what the citizens can do. So we have these 8 factors, which are the first 4 constraints on government powers, absence of corruption, open government, and fundamental rights, which measure these first constraints on authority, and then order and security, regulatory enforcement, civil justice, and criminal justice, which measure essentially constraints on what people can do. Each one of these indicators includes sub-indicators. In those sub-indicators, we measure outcomes that rule of law societies want to achieve in practice. For example, when we talk about the civil justice system, we talk about the accessibility of the civil justice system, or the absence of discrimination, the absence of corruption, or an effective enforcement within the system. So overall, we have a set of 44 indicators that comprise the Rule of Law Index. Next one. Next slide. So the Rule of Law Index 2022, the approach that we follow is to try to look at how the people perceive and experience these outcomes. So it measures the rule of law experiences of people worldwide in 140 countries and jurisdictions. And the way that we do this is by collecting information from the public and from legal practitioners in each one of the countries. So overall, the report summarizes the views of 154,000 people just on their day-to-day experiences, as well as more than 3,600 experts, lawyers that interact with authorities, with the justice system in their countries, and who can provide an assessment of how, in practice, the system works. All this information, which essentially makes up more than 550 perception and experience-based questions, are summarized in 8 factors and 44 sub-factors. Next slide. So all the information is presented in the form of country profiles. You can check all of them. So all the scores are between 0 and 1, where 1 is more adherence to rule of law, and you can see the results for each one of the countries for this year. Next. You can also see all the information in the website, where you can see the indicators as well as the trends over time since we started collecting information. Next. We have been publishing the index for several years, so the index is used by a large number of stakeholders, starting from governments and multilateral agencies, bilateral agencies, multilateral agencies, NGOs, the media, and the business to assess the rule of law situation in each one of the countries covered in the index. Next. So let me just present now some of the trends that we have seen around the world. Next slide. So the rule of law declined in 61% of the countries between 2021 and 2022. These declines, we observed them in almost all the regions of the world. What that means is that out of the 140 countries, in 85 countries, the rule of law declined, and that adds up to about 4.1 billion people who live in countries where the rule of law declined between 2021 and 2022. And this is driven by 3 main factors. Next slide. The first one is an erosion of checks and balances, a rise in authoritarianism around the world. So this essentially is legislative constraints, judicial constraints, constraints by independent agencies, or non-governmental checks such as the media. So we have seen an erosion in many of these countries. Next slide. The second is an erosion of fundamental rights. So the indicator on fundamental rights, which essentially measures just a core of civil and political liberties, fell in 66% of the countries between 2021 and 2022. And finally, the third driver, next slide please, is just an erosion in the effectiveness of the civil justice system. Essentially, just the indicator fell in 61% of the countries, and this is driven by a few factors: rising discrimination, just as a result of the pandemic. Just some groups had more difficulty in accessing the civil justice system, but also continuing delays. Just some of them are residuals from the pandemic, but just we are seeing that in some countries this is still a problem, as well as weakening enforcement of decisions. Next. Next slide. So when we look at long-term trends, starting to look at the results from 2015 to 2022, we see that the rule of law has declined in 64% of the countries worldwide. Next slide. So in this graph, you can see the number of countries where the rule of law has improved and where the rule of law has declined, improved in blue and declined in red. As you can see this year, the number of countries, as I mentioned before, is almost 61%, the number of countries that declined, the percentage of countries that declined. This is smaller than previous year. The previous year saw the height of this figure where more than 70% of countries declining, but it still is much larger than the number of countries where the rule of law has been improving. Indeed, when we look at the quantity, the amount of the decline is much larger in those countries where the rule of law has been declining than in those where the rule of law has been improving. Next. So let me show you some of the trends in the Asia Pacific. Next. First, this slide shows the countries that we have in the index in the Asia region, the position of each one of the countries. And as we can see, the region is very diverse. So we have countries that are at the top just of the global rankings, but also some countries that are at the bottom of the global rankings, and then a large mix of countries, as we will see in a minute, that face different challenges in the rule of law. In this chart, you can also see the changes over the previous year, as well as the regional rankings of each one of these countries. Next. So the trend that I showed before essentially just mirrors some of the trends in Asia Pacific. So, but before going into what has been happening, just as I was saying, the region is very diverse, and we can see it in these three dimensions as well: constraints of government power, checks and balances, where we can see some of the countries at the top, but also many countries which are at the bottom of the global rankings are in Asia Pacific. Next. The same is true when we look at fundamental rights in Asia, just a very heterogeneous region with New Zealand, Australia, Japan at the top, but we also have some countries, just as China, Myanmar, just at the bottom. Next. And the same in justice. Here you can see the scores not only for the factor related to justice, but also some of the factors, for example, related to accessibility, as I was saying before, delays and enforcement, where we see just a lot of dispersion just across the region. Next. So the trend that we saw globally, we're seeing it as well in the Asia-Pacific region. So in the case of Asia, 71% of the countries, in 71% of the countries, the rule of law declined. So out of the 21 countries in the region, 15 declined and 6 improved. Next. When we look at the specific drivers, just kind of the same image that we have in the global trend. So the checks on government powers decline in 62% of the countries, as you can see in the map. On the right, the bars show for each one of the different elements that we use to compute this indicator, we have seen that in most countries, the indicators fell. So at the bottom, you can see, for example, 1.1, which is legislative constraints, or 1.2, which is one of the topics that we're going to be covering in this meeting, which is judicial constraints, or an approximation for judicial independence, in which more than 70% of the countries in Asia this declined. Also 1.3, which measures the independence of independent audit and review agencies, that also declined in a large number of countries. Next. Fundamental rights also declined in a large number of countries. 76% of the countries saw a decline in this indicator, and particularly driven, as I was mentioning before, rising discriminations, which is 4.1, as well as freedom of opinion and expression, that also has been constrained in a lot of countries in Asia, more than 70%. Next. And finally, just effectiveness of the civil justice system, that fell in 71% of the countries in the Asia-Pacific region, mainly driven 7.5, which measures delays, a consequence of the pandemic, but also just weak enforcement as measured just in 7.6. Next slide. So when we look over time, so the decline is even more pronounced when we have been when we look at the scores comparing between 2015 and 2022, the rule of law has declined in 81% of the countries in the region. Next. And this is just looking at the percentage of countries for each one of the different indicators. We see that most of the reduction has happened in factor 1, which is checks on government powers, and factor 4, fundamental rights. Perhaps the only factor that has, in which more countries have improved, is regulatory enforcement. Next. Finally, let me just show you some comparisons just of some of the countries that we measure in the index. In these tables, you can see the score in the latest edition of the index for the rule of law, as well as each one of the indicators, as well as the changes that we have seen last year, as well as during the last 5 years. India and China, which we know two of the main economies, or the two main economies in the region, and that in some cases face similar challenges, particularly when we look at this over time, particularly the challenges related to constraints on our powers and fundamental rights. Both countries have shown continuous declines, even though they have started from different places. India has higher scores to begin with in constraints on our powers and fundamental rights than China. But on the other hand, China, just on issues such as absence of corruption or the performance of the civil justice system, has been scoring higher than India. This decline, so next slide, please. Next. So when we add Hong Kong, I mean, Hong Kong is an interesting example, so because it allows us to understand better what's happening not only in Hong Kong, but also in China, where we have seen just these declines in rule of law scores, but particularly in the scores on checks and balances and fundamental rights, where rule of law, or where Hong Kong has been declining in scores. Next slide. Another comparison, for example, of two similar economies, so Hong Kong and Singapore, just the two countries have higher scores in rule of law, but both countries, particularly Hong Kong, has been declining recently when we look at the trends, for example, between 2015 and 2022, particularly in issues such as fundamental rights, criminal justice, and checks and balances. So even though the rule of law score has declined as well, just between these years, just driven mainly by these three elements that I just mentioned. Singapore, in contrast, has been declined as well, but obviously not at the same magnitude. Next. Two other countries that has remained relatively stable, Korea and Japan. Korea had some declines a few years ago, but just in recent years, just for the most part, has remained quite stable. Just two countries where the rule of law is stronger in the region, particularly Japan. Next. Oh, I think next. Yeah, that one. And then finally, just two other countries, Malaysia and Indonesia, with countries that have experienced several important changes during the last few years, some improvements when we look at this from between 2015 and 2022, both in Indonesia and Malaysia, but also when we look at recent trends, there has been declines, particularly in constraints on our powers, fundamental rights in both countries, more pronounced in Malaysia, but still in Indonesia we're seeing some of the same trends. And with this, thank you very much. I'm just finishing my presentation.
Alejandro, we would like to ask for your keenness to kindly remain on stage actually, but we would like to invite every VIP delegations to join on stage as we would like to conduct photo sessions. Multimedia team, please prepare yourself and capture the moment. For the committee, please kindly keen to assist all of the VIP delegations to join on stage. We would like to conduct photo sessions. Ladies and gentlemen, we have such a wonderful and remarkable expert from the Justice Forum today. So this is such a remarkable moment as well. Selamat pagi, Bapak. For multimedia team, please kindly prepare yourself to capture the moment. Ladies and gentlemen, this will be our VIP delegations and guests. We're going to capture the moment. Also, please kindly keen to set the arrangement or the positioning of the delegations. Okay, official positions. VIP, please kindly do not return to your seat because we're going to invite everybody to join. We don't have okay. Do apologize, that's a revisions on the schedule, ladies and gentlemen. All right, VIP delegation, thank you so much. Please kindly return to your seat. All right, ladies and gentlemen, we're still waiting for the VIP delegation to return to their seat before we proceed to the next sessions. Bapak Ibu, VIP terima kasih, kami minta kesediaannya untuk kembali ke tempat duduk masing-masing. Distinguished guests, ladies and gentlemen, after the photo sessions, we will have coffee break for 25 minutes ahead before we proceeding to the first panel discussions of regional data from the 2022 WJP Rule of Law Index. The panel discussion will be proceed at 10:30 a.m. sharp. So at the moment, please kindly enjoy the tea and coffee and also snacks provided at the foyer area of the Istana Ballroom. Bapak Ibu sekalian, kami persilakan untuk coffee break sejenak selama 25 menit ke depan. Kami sudah menyediakan teh kopi dan snacks di area foyer Istana Ballroom Sari Pacific Hotel Indonesia. Ladies and gentlemen, we will have coffee break for the next 25 minutes before we proceed to the first panel discussions of the day. Please kindly return to the Istana Ballroom at 10:30 a.m. sharp. Distinguished guests, ladies and gentlemen, we would like to kindly invite you back, joining us in the Istana Ballroom, as we would like to proceed to the next sessions, which is the first panel discussions of regional data from the 2022 WJP Rule of Law Index. Bapak Ibu sekalian, para partisipan, kami minta kesediaannya untuk kembali bergabung di ruangan Istana Ballroom. Kita akan memasuki sesi selanjutnya, yaitu panel discussions. Ke Jupiter. Yang ini kan yang nanti siang habis crossover kedua. Apa namanya? Taman. Agar Pak Jimlinya udah ada belum? Kita kan Jimli. Jimli apa Jimli? Ini kecil ini. Distinguished ladies and gentlemen, we would like to invite you back to joining us in the Istana Ballroom as we would like to proceed to the next first panel discussions of regional data from the 2022 WJP Rule of Law Index. Bagi para partisipan yang masih menikmati coffee break di area foyer, kami minta kesediaan Bapak dan Ibu untuk bergabung kembali di Istana Ballroom, di mana kita akan melanjutkan ke sesi panel diskusi.
Hadap ke sini. Hadap ke sini.
Ladies and gentlemen, please kindly fastly return to your seat as we would like to proceed to the next sessions of the first panel discussions of regional data from the 2022 WJP Rule of Law Index. Bapak Ibu sekalian, kami mohon kesediaannya untuk segera kembali di Istana Ballroom. Kita akan memulai sesi diskusi panel pertama pada forum hari ini. Ya, udah lihat. This will be the first time I haven't invited everyone and the speakers and the panel is already sitting on the stage. Okay, ladies and gentlemen, without further delay, we would like to introduce, this would be our moderator for the panel discussions, Alejandro Ponce, Chief Research Officer, WJP, and also the panelists, Stephen Tiru, Vice President for Australasia Commonwealth Lawyers Association Malaysia, Jimli Asidik, former Chief of Constitutional Court of Indonesia and Professor of Law, Prashad Kumar, President Bar Association of India, Victor Daos, Chairperson Hong Kong Bar Association, that already joining the panelists online as well. Mr. Moderator Alejandro Ponce, please kindly lead the session. Bapak Ibu, kami mohon untuk tidak berbicara selama panel diskusi berlangsung. Ladies and gentlemen, we would like to proceed the panel discussion of the day. Thank you very much.
All right. Well, thank you very much. We're going to continue the conversation that we just started a few minutes ago about some of the main challenges that we're all facing in the region in terms of rule of law, and reflecting a little bit on some of the findings from the rule of law index. We have heard we have very distinguished panel today to talk about this. And the way that I would like to structure the conversation is perhaps to talk about some of the main challenges that we have heard and that are the basis for this conference. So the very first one, of course, relates to the issue of rising authoritarianism and the checks and balances. And these are issues that we are discussing today when we discuss judicial independence, misinformation, and so on. Sometimes the way that I think about this is if we think about the context first in which these trends happen, which is important to understand, rising inequality, more recently a health crisis, that somehow just are important to understand some of these trends. So on the other hand, we have sometimes governments which may act in some ways in authoritarian ways, just either by passing laws or just in the discourse or through some of the proposed reforms, just that drive this trend. But on the other hand, we also have complex institutions. In all the countries, there are institutions precisely built to prevent these and to encourage participation, discussion, and so on. And they have a lot of different forms. And it's really just the movements that we see in all these trends really reflect these constant discussions and so on, just and happening between just on one hand these more authoritarian tendencies, but on the other as well some of the responses from different institutions, either from the judiciary, legislative, independent agencies, anti-corruption agencies, audit agencies, the media, civil society. So in a complex ecosystem that allows us to understand really just the accountability just as it happened in this country. So I would like to first just obviously discuss about these themes, and then something important as well that we're going to be discussing today, which is this broader issue of delivering to citizens, and in particular, access to justice. How can we just build systems that can better deliver to people justice solutions that they may want? And in order to do that, just and to kick off the conversation, first I would like to ask our panelists about the challenges that we're facing, and then leave at the end some space for reflecting about possible solutions just to address some of these challenges. So the way that, just to make it as dynamic as possible, I would like to ask you first to reflect on these challenges on this accountability system, checks and balances, and rising authoritarianism. I will ask you to just speak about your experiences and try to limit yourself to 3-4 minutes so that we have rich conversation. And probably just, I'm going to start with you, Stephen, just to give us your views on this from a more regional, perhaps, point of view, given all your rich experience. Also, you know pretty well the case of Malaysia, but more broadly, just the case of Asia on these tendencies on accountability.
Thank you, Alejandro. Good morning, selamat pagi. Let me just explain my role. I am the Vice President of the Commonwealth Lawyers Association for Australasia. Australasia is obviously a very big area, and it represents, we represent the common law jurisdiction. So my comments today will be confined to what is commonly called the common law system, and where we have in our system of government a separation of powers scheme, which is also called the Westminster system. It's in that context in which I wish to give you a bit of an overview. And although the index that you saw and you heard about this morning is about 2022, if you permit me, I would like to put this as a thesis for us to consider in all our deliberations, that we cannot see 2022 in isolation. What we have in 2022 is very much the aftermath of the COVID pandemic and in fact now in the endemic stage in many countries. What we have seen in the Australasia region, and I have in mind Malaysia, I have in mind Hong Kong, I have in mind the South Pacific nations like Samoa, and now in fact Kiribati, spelled Kiribati but pronounced it Kiribati, is a phenomenon that is, I think, reflected in your general observation of decline. And that is unfortunately the bleak picture that we have got and which I think persists. And it's simply this. In the COVID pandemic period, you saw government or governmental powers being concentrated in the hands of the executive. And it was basically government knows best, and it's government that needs to save and protect. And in some countries, if you take Malaysia, we had emergency laws put in place, totally unwarranted in our view. And in many other countries, if you take Hong Kong, it is during the COVID period that you had the national security laws for China, of China for Hong Kong, passed and brought into a place in Hong Kong. And that way, we have seen that in Samoa, there were attempts to amend the constitution to give the executive power. And at the moment, we are seeing a judicial crisis being played out in the Kiribati. Now, what all of that means is simply this. You've had executive overreach since 2022, where the executive in the system of the separation of powers, the executive has made the legislature, which is in any event controlled by the executive in most common law jurisdictions, and the judiciary subservient. Now, if you take Malaysia as an example, when we put in place, or when the emergency was promulgated, emergency laws came with what is known as ouster clauses, meaning actions taken by the executive were put beyond the scrutiny of the courts. The courts could not adjudicate on laws that were passed, executive action that were taken. Now that happened during the pandemic period. Now the difficulty that we have and that we see in most jurisdictions is, and we all will know this, power is addictive. Executive power is very addictive to the executive. Once accumulated, the executive does not let it go easily. And you're seeing the vestiges of that now in the endemic period, where executive government remains powerful. Executive government will not yield that power very easily. When problems creep up, the pandemic may be used as an excuse. There may be other reasons of national security that may be used. So if you want to put your finger on why we are seeing a decline across the board, please look at what I consider to be executive overreach. Let me tell you what's happening in the Kiribati. At the moment, Parliament has just decided that the Chief Justice has to be removed. And all the Chief Justice did was he wrote an article generally about the administration of justice in Kiribati. And when the government removed a High Court judge by the name of David Lamborn, because he was married to the opposition leader, and that removal was challenged in courts, and this Chief Justice decided in favor of that judge, he's been disciplined, and there is a recommendation that he should be removed from office. Now that's executive overreach, because executive says that they know best. They know best what is good for the country. The system of check and balances, which was mentioned this morning, exists by and large just in form. Yes, there are other jurisdictions, and I will just conclude with that, where the judiciary has played its part, and I like to think in Malaysia, post the emergency, our judiciary has been active, but that's not the case in most jurisdictions. So keep your eye on how the executive is functioning now in the endemic period, and we ought to be concerned that these addictive powers that the executive has accumulated for itself, these powers must be recalibrated within the system of separation of powers powers return rightfully to the legislature, return to the judiciary. We are no longer in the pandemic. We go back to where we were before the pandemic, and maybe then we will stem this decline. Thank you.
Thank you very much, Stephen. And first of all, just my mistake, because I mean, even though I introduce everybody, just a couple of things. I mean, first is just we made a change, so we don't have Lauda today with us, but we have Jimmy Ashidik, is that correct? Yes, who is the former chief of Constitutional Court of Indonesia and professor of law. And we also have Victor Dos online. So unfortunately, he got sick just on his way to the conference, and but he's going to join us online. So just whenever he's just available, just we'll pass the microphone to him. So sorry about that. But just Prashant, so if you can comment just on the situation of India in particular about this rising authoritarianism trend.
Thank you, Alejandro. Apart from representing India Bar, I had the occasion to serve in Law Asia also, alongside Stephen. Taking from where he has left and talking about the Westminster model, I have a couple of observations to add. One, in last decade or so, when data availability and analysis, we are doing it for promoting rule of law, but that also works for inhibiting rule of law. So now the political class has learned the electoral dynamics in a way that by speaking to their specific constituency, which can bring them into majority, and to the specific exclusion of others. Because earlier, the appeal used to be broad-based. Now the electoral appeals have become exclusionary to a certain extent to get to your core constituency and build your coalitions, your majority. So that is one trend which has led to it. Secondly, apart from pandemic, the general structure of bureaucracies in the Westminster model countries has been in a way that constitutionally they are insulated from the executive interference or the political interference. But in practice, it works that, these bureaucracies are very, very powerful vested interests by themselves. So most of the cases in India are cases against the state, and it is not the policy sometimes, it is the executive action at the bureaucratic level. So the check, when there is a kind of a compact, unspoken compact between the political executive and the permanent bureaucratic executive, is a complex which is demolishing and limiting the powers of the institutions which bring in checks and balances, including judiciary. So in India's experience, the whole drive, which became a bipartisan drive politically, was pushed by bureaucracy because the Indian Supreme Court struck down a law which gave immunity to the higher civil servants, that they will first have a sanction from their own group, only then they can be persecuted. So that brought a full-scale blowback against the judicial institution, which continues till today, in terms of funding, in terms of all other ways that the power. So there has emerged a compact between the executive part, which is the bureaucracy, and the political part. Secondly, which is, unfortunately, I'm talking about the trends which should be positive to push more democracy, more accountability. Security, in India, one of the index where we have improved is security. And this. So there, the global UN frameworks on terrorism, anti-money laundering and all, now they are being pushed through agencies that are concentrating more on the opposition and limiting the democracy by foisting cases, having more powers, and the powers when they have been challenged in terms of one law and prevention of money laundering act and all before Supreme Court, the justification of government has come from all the UN documents. So that is another area, where, all international protocols, how in different situations they are going to work out. And third is, of course, India has seen after a long time a majority government, but that majority is based on exclusionary appeal to a core set of voters. And that is what is creating issues which are reflecting in what we see in the rule of law. But fortunately, from the judicial side, more or less at the Supreme Court level and all, the judicial independence is what is standing as a bulwark to somehow contain the overall demolition of institutions which is being pushed. And one of the key cases being heard right now is the court wants the appointment of election commission, chief justice to be part of a collegium or a recommendatory body, then the government in power appointing the election commission, which has to be a very independent body to sustain democracy.
Thank you. Thank you very much, Gimli.
Thank you. Assalamualaikum warahmatullahi wabarakatuh. Good morning, everybody. I would like to thank you very much, especially to the organizer inviting me. This is quite an honor for me. According to the schedule, I should have present my discussion on this coming 1 o'clock, but I'm sorry that we have to change with Pak Laude. He will replace me and I replace him this morning. On the issue of rule of law, I think we are all over the world experiencing from a very big problem today, because we are facing a potential big change toward the middle of 21st century, just like what happened during the middle of 20th century. There is war, there's potential world war, and so forth and so forth. And it happened also in Russia and Ukraine. And today, the rule of politics and economy becoming stronger and stronger, work together, and undermine law and judicial power in every country, all over the world, and including happening also in my country, in Indonesia. So this is one problem we are facing. The second is, of course, about the development of disruptions in technology. Today we are facing the post-truth era. This is not the era of information, but era of misinformation. This is not era of communication, but the era of discommunications today. And of course, it's influenced the performance of the rule of law all over the world, including in Indonesia. So, ladies and gentlemen, this is very problematic. And the third thing is very serious, is what is happening in the last 3 years. We are suffering from COVID-19 outbreak. And you know that these 3 years disasters has been misused and hijacked by politicians to make any decision in the rule making, rule application, and even law enforcement, just according to the self-interest of every parties in any case. So we are now facing, so many cases in lawmaking, like in the parliament in Indonesia. Sometimes one law should be discussed 6 months, but during the pandemic period, in the last 3 years, there is one law just discussed only 1 week, and then passed by the parliament, decided just 1 week. And the participants in the parliaments, sometimes only 10 persons, and the rest by using Zoom. This is the way lawmaking process, without due process of lawmaking. Due process is not only due process of law enforcement, but due process of lawmaking also. So this is why in Indonesia, we have judicial review mechanism on the constitutionality of law in the Constitutional Court and on the legality of regulation in the Supreme Court. But so far, there is no one yet formal review of law and regulation has been accepted by these two courts. Only material judicial review. So we know that judicial review, there are two kinds of judicial review. Material toetsingsrecht, material toetsing or material review, and formal review. This formal review case in Indonesian experience never accepted by these two courts. But just last year, that is the first landmark decisions made by this Constitutional Court, that the first very thick law on Cipta Kerja, what is that? Job creations. It is in the history of Indonesia. It's very thick, 1,000 pages of law, and it is only 100 days decided by the parliament, and that law was annulled by the Constitutional Court because it is against the due process of lawmaking. So that's the first experience, and it shows that this pandemic, COVID-19, is hijacked by the politicians. Just only 100 years, they decide that thick law. This is one example. And this pandemic, in 3 years, it is happening. We get problem. If I read that there is a survey showing that Indonesia shows that Indonesia get the good rank in the government constraint, I don't think it is true as what is happening in the last 3 years during the COVID-19. So this COVID-19 is really a problem, declining the quality and the integrity of our rule of law. I think everywhere it is happening, but especially in Indonesia, it happened. And you know that one of the judges of the Constitutional Court was fired by the parliament, recalled by the parliament, while there is no regulation, there is no law, no articles that can be used by the parliament and by the president to fire judges like that. So this is also not due process of law. But the president just signed the decree, and nobody, and yes, many persons scream for that. But during the COVID, there is so many, limitations. Yeah, the people may express their freedom. Yes, they may make demonstration. Yes, but there should be social distancing. You should have your masker. So this is a limitation. So I think the quality and the integrity of the rule of law today declining everywhere, including in Indonesia. Number two, you know that Indonesian traditions, political traditions in Indonesia, we are a republic according to the constitutions. But Indonesian culture in politics really very feudalistic, and still most people, idealize monarchy, political culture. Because during the 1945 formulations of our first constitutions, there is no articles decided by voting, all by acclamation, except one. That is when we choose republic or kingdom. During that time, the framers of our constitutions, 55% choose republic. But there were 6%, actually 9%, but when it is voting, only 6%. 6% did not want Indonesia become republic. They want kingdom. So because they make a very big debate, so the decisions must be taken by voting. So this is the only voting issues during the framework of Indonesian constitution. So according to my analysis, if during 1945, before it is decided, we make referendum first, maybe kingdom is the winner, not the republic. So this is showing that Indonesian culture is still feudalistic. And what is ideal during this? Because the rule of law is not compatible with the rule of man. In feudalistic culture, the ideal is the rule of man. And today, we have 7 presidents. One of the presidents, I always use blood, blue blood and red blood. Okay? Now, the most red blood of our president is now to this president because he comes from the market. He was a businessman. The 6, they have half blood red, half blood blue. But today is the most red blood president of Indonesia. But when he become the president, his blood now become very red, very blue. Yeah. So this is what I would like to share with you, that including in Indonesia, the quality and the integrity of the rule of law declining. So we have to think how to move on, how to make it improve for the future. Thank you.
Thank you. Thank you very much. And I think we are going to hear from Victor. Is he online?
Yes, I'm online. Can you hear me?
Yes, we cannot see you, but we can hear you.
Okay, well,
go ahead,
I
Victor.
hope something is being done. You should be able to see me soon.
There we go. We can see you now.
Excellent.
Okay.
Thank you very much. Can I just say I'm terribly disappointed for not being able to join all of you in person. I can say with personal experience that 3 years on, the pandemic is still haunting us, and I'm an example of that because my household has just been tested positive yesterday. But as you can see, I'm feeling all right. There's a slight discomfort. But can I kick off? I have actually originally prepared a few PowerPoint slides. If the operator can kindly pull up slide 2. What I propose to do is to tell you a bit about myself and Hong Kong. I will go into a lot of the challenges that the 3 speakers have mentioned, how that relates to the situation in Hong Kong. And I would also just like to make a couple of comments about the regional data that the the index reflected in the index and give some brief comments about them. So, insofar as myself is concerned, I'm the chairman of the Hong Kong Bar Association. In Hong Kong, we are a common law system, and we basically operate in a very similar system to what was the same as the colonial days. So it is basically a British system. We have a split profession. So we have an independent bar, and we have the solicitor profession. So in the bar, there's about 1,600 of us. And in the solicitor profession, there are about 12,000 members. So we work closely with each other, but those are the two branches of the profession in Hong Kong. As a lot of you will know, Hong Kong has a unique system in that we are, of course, a special administrative region in China, but we are the only jurisdiction within mainland China that operates a common law system. So constitutionally, it is unique in the sense that there is, of course, a relationship with part of China, but insofar as jurisdiction is concerned, we operate in a total different system that is fully bilingual. So in most court hearings that I go to, we still use English to make submissions. For practical reasons, a lot of the hearings, especially taking of evidence, are conducted in Cantonese because that is the local dialect. So there is this interplay between the language and the system here. Some of you would know that from 1997, Hong Kong basically reunited with China again. There was written into what is known as the Basic Law. The idea was basically there was not going to be any change for 50 years from 1997. So there's in Hong Kong, we always talk about 2047 because that is supposed to be the end of the 50 years. And how that would change was something that was quite unclear in 1997. After all, 50 period is a long time. And the idea, I think, is also that Hong Kong will undergo transformation. Mainland China will also undergo transformation. So I think the wisdom back then is, let's make sure nothing changes for 50 years. From then on, who knows, because it's such a long way to go. Now, as you all know, Hong Kong had faced many challenges over the past few years. There were many events that took place in 2019. You have all read about it. Some papers give a more accurate description. Some, I feel, were not so accurate. But what I can say, I think quite fairly, is that we have our fair share of unrest and troubles in the year before the pandemic. So our trouble started slightly earlier. Moving towards the end of the pandemic, what we are seeing is that, of course, there are very significant challenges to the rule of law brought by what happened in 2019 and also by the pandemic. I think we are all in the same boat in many ways. What we've been seeing recently is that I think the messaging from mainland China, from President Xi, when he visited Hong Kong in July this year, is that there were a few key takeaways that has an impact on rule of law and where we see Hong Kong. He was obviously very keen to emphasize that they want the common law to remain in Hong Kong beyond 50 years. I think even mainland China, who operates on a fundamentally different system of law, sees the common law as something that they're keen on keeping for Hong Kong. And they have emphasized a number of times that they would want judicial independence to continue. Now, of course, that is the message. Practically speaking, we know there are many challenges, and this is not a session about Hong Kong. I won't spend too much time on it, but just to give you an overview. But I think for us, continuation of a common law system is something that is beneficial to the people of Hong Kong, and also in a way compatible with national interests in China. As you may have all heard, they're keen on keeping Hong Kong as an international finance center. There's the Belt and Road Initiative. And in a world where we all talk about polarization and decoupling, having a system of law that is compatible with many other jurisdictions in the world has obvious advantages. So conceptually and recent development-wise, these are what we are seeing. In terms of the challenges brought by COVID over the past few years and how the government has behaved, Stephen kicked off by referring to some of the themes. we see similar issues. As I think Hong Kong is not alone because of the lockdown we face. There are backlogs in cases that are going through our criminal courts. Criminal courts are working very hard to try to clear that backlog. But I think Hong Kong is not alone. The situation in Hong Kong, I think, is more challenging in that because of the events in 2019, there have been more prosecutions. And in order to ensure that they are treated fairly, some of these hearings are very long. So we do have criminal cases that last for 30, 45, 60 days, as you name it. So that is clocking the system. And as we all know, justice delayed is justice denied. So we have raised on a number of occasions that it is not acceptable, and we're urging the prosecution to speed up. On the pandemic front, we also see good signs and bad signs. Now, what has been going through our constitutional court is also interesting. Like Europe, we have had our fair share of judicial reviews. So individuals challenging the executive's policy relating to COVID, vaccine pass, the fact that you need to be vaccinated to enter certain of the premises. That has gone through our courts. The courts have held in favor of the government, holding that is proportionate. On the other hand, there have also been cases where the government pushed certain policy in a very speedy manner. We've had a recent case where there were a few doctors who issued medical certificates to exempt people from being vaccinated. But I can tell you the number speaks for themselves. 5 doctors issued like 20,000 certificates in a short period of time. And once you hear those figures, you know that there's something wrong with them. Now, the government decided to invalidate the certificates overnight. That went to our court, and our court basically held the judge in charge of the constitutional law list says that is an abuse of power. You can't just cancel those certificates like that without due process. The government backed off, amended the legislation immediately. So the pandemic, I think, has shown us that there are significant challenges. But on the brighter side, I think the pandemic has also shown us that insofar as controlled by the judiciary over the executive, there are examples that is being done very effectively. Now, I'm taking up too much of your time or talking about Hong Kong. Can I just move on to one aspect to do with the index? I'll spend 2 minutes on it if you don't mind.
Go ahead.
If the operator can pull out my slide 2. I'll start speaking and
go ahead. Go ahead. Yeah, we will try to put it up.
What I wanted to say is, as you can see from the discussions this morning, across all indicators, I think our region, in terms of Asia, East Asia and Pacific region, we actually, the regional average remains above the global average. And you can see that in terms of overall score of 0.59, this compared quite favorably with the global average of 0.55. And the regional average outperformed insofar as the following 3 areas, which have most significant impact: order and security, absence of corruption, and civil justice. In contrast, at the same time, the region performed less impressively when it compares to the rest of the world when you talk about constraints on government power, open government, and fundamental rights. Now, very briefly, I think the comparison with the global performance perhaps reflects policy priorities and the cultures in at least some of the Asia-Pacific jurisdiction, with greater emphasis on order and security. It also speaks volume, I think, to the fact that the rule of law is a malleable concept, susceptible to very different interpretations. But if I can just say this, I think the indicators under the index have actually done an excellent job in trying to balance what some of the scholars call thin concept of rule of law, which focus on procedure rules, and what is sometimes known as the thick conception that includes substantive characteristics such as self-governance, fundamental rights, and freedom. So I think our index actually strives to be culturally competent so as to be applied to different types of social and political system. But there are, of course, areas where we can improve, but I just want to congratulate the hard work of those who actually compiled the index of trying their very best to be culturally sensitive in putting these figures together. Sorry, I've taken up way too much of your time. I think I really need to give some airtime to everybody else. Thank you very much for listening to me.
Thank you very much, Victor. And well, obviously, it's extremely challenging to try to talk about a topic such as the rule of law in Asia in 1 hour. So, and we have heard a lot of different, key points. And I will just want to give the speakers a moment to start thinking about some of possible solutions of what to do, how to think about moving forward in this problem. And we have heard, we know that the COVID actually brought just a lot of challenges, both in terms of the new executive powers in many countries, but also just in terms of delays and circumstances that made much more difficult the situation. However, just many of the things that we have seen as well were pre-COVID. So the COVID just probably accelerated some of these tendencies that we have seen in these countries. At the same time, we have heard some positives. We have heard about judicial review, judicial independence, and how in some cases this has helped just confront some of these challenges. So in the last 15 minutes, and just essentially we're before lunch, so I know that this is challenging. I would like to ask you to simply just reflect on what can we do. And understanding that this is challenging, but at the same time, it's an ecosystem composed of many different actors, and different actors have a role to play. So let's start with you.
It's a bit of a challenge, a very broad question, but let me just focus on access to justice. Access to justice can be looked at formally, which is effectively just having access to a physical court, so your dispute can be resolved in the court, and also substantively, in the sense that you mentioned whether the judiciary is in this post-COVID period up to the challenges that COVID has presented. Now, in terms of the formal access to justice, I think, well, there have been many casualties during the COVID period. Rule of law certainly was one of the main casualties. But if there's one silver lining that I can identify over the COVID period, is how many of our courts almost overnight digitalized. They were able to take on online hearings. Now, that's not a case throughout the Australasia region. I was in Fiji about 2 months ago, and Fiji is struggling with it. And we spoke to them about
in progress.
Be careful with what you're going to say now.
Yes, right. Good things about Malaysia. The courts are functioning very well in the online system. Have you got that recorded? Yeah, okay. Right, okay. But that's the truth of it. In terms of formal access to justice, I believe the COVID period has moved things along, and we are seeing more and more courts embracing it, litigants embracing it. Now, in terms of substantive access to justice, because it is just not about turning up in court, switching on your Zoom, and being able to address the judge. You must be able to get justice. Now, that is certainly the challenge. That challenge, I think, will be dealt with in another session later on the independence of the judiciary. And that is a mixed picture. I don't share the view that judicial review has been on the rise in all jurisdictions. In many jurisdictions, the courts have deferred to the executive, saying that these things, measures that were taken, actions taken during the COVID period and the post-COVID period, is no longer a health issue, it's a national security issue. All right? So it depends on the jurisdiction you look at. And it's important when we speak about access to justice that we look at that very carefully. And if you're talking about solutions, and we must talk about solutions, well, as a practicing lawyer, for me, what's upmost is the independence of the judiciary. And that is under attack in many jurisdictions. And we must look at ways and means by which that fortress cannot be challenged. Those principles We may come from north, south, east, west, but when we talk about the independence of the judiciary, we all speak the same language. We want a judiciary that is above the influence, beyond the influence of the executive or any other party. A judiciary that exists to provide equality in law for all. No one is treated differently in the courts. And the judges who cannot be influenced or cannot be in any way punished. And I will say something about that when we talk about independent judiciary, how judges are being punished because they are independent. We must be alert to prevent that. That must be a strong statement that comes out. Thank you.
Thank you. Prashant?
Again, when we talk about the rule of law index, is the trends to surveys, data, and others. So now, building on that, as I, in informal discussions, I said that India's Justice Ministry looks at the index and also has one of its objectives, how to improve the ranking. So in that regard, a couple of things which will reflect in years to come is like, we are seeing that India's position has declined in civil justice. Part of it, COVID, and also because of the judicial infrastructure. So one thing which, we can look at more and have a collaborative effort is a national judicial data grid has come into place, which gives all the cases pending where, for how long a duration, and under which statute and all. So that can provide space for further research, and in fact things are being done to reduce pendency, which in turn increases access to court. It is not just being able to file the case and have it up for hearing, but that the case decision is done in a short time. This pendency, acts as a block to that. So both in the civil justice and criminal justice. Secondly, that also that some of these data and others can be utilized to, because in India we have very strong judicial review. And if there is a well-researched petition, we can go to the high courts and Supreme Courts to have that deficit in governance or institutional functioning or its independence or other aspect addressed. So that dialogical space which has been created over last 40, 50 years in India, where court and lawyers and the citizens can engage to bridge these gaps to try to structure solutions is very important, and I think that effort is also to be looked at. Lastly, and I had informally pointed it to Betsy, that the role of bar associations should also become a factor. How independent and proactive the bar associations are. Because ultimately the independence of judiciary is in a very large measure dependent on a strong bar. So if you have a strong bar, so that bars are also encouraged to play their roles more effectively. So if that becomes a factor, I think that will also lead to improvement. That will also encourage bars and lawyers who are, defenders, who defend human rights and all, to take these things further. And I think we can have region-wise and country-wise dialogues with your team and the bar associations and other stakeholders, not only to create further awareness, but also to improve the tools in the process, where, peculiarities of a region or a governance system can be addressed more, defined, and perhaps apart from a journal report, you have a 2-page, 3-page specific report on the factors behind how these trends are emerging. So I think that will be helpful. Thank you.
Thank you. Jimli?
So I think I'm glad to hear the optimism about the development of the rule of law. And in general, we can look at the optimistic view for the future. But of course, rule of law is very complex. Many aspects of the rule of law may be not all idealistic as we show our optimism in one aspect, and the other aspect may be different. And in one country and to the other country may be different too. And sometimes we can also count on the data surveyed, because we are experiencing today. We are, just in recent days, recent weeks, that never happened in Indonesia. Very big mafia inside the police, Indonesian police. It's, everybody talk about the police problem, Indonesian police problem in the last 6 months, and this is in the upstream. While the downstream, we have two justices of the constitutional of the Supreme Court was caught by anti-corruption commissions because of bribery. And number 3, one of the justices of the Constitutional Court recalled by the parliament and endorsed, adopted, and decreed by the president. And this is really without due process of law in, firing the judges of the Constitutional Court. And this, of course, influenced the independence of judiciary, the independence of the Constitutional Court. But of course, this we cannot. Maybe it is not yet become one of the data when the survey showing that Indonesia becoming more, what as shown by Victor Dawes, that Indonesia get improvement 4 point, and of course from that data maybe as in general views, but in 1 or 2 cases happening in Indonesia, it's not that the case is not like that. So I think we hope that we can improve our performance in our respective countries. And as far as in Indonesia, we think that the impact of the pandemic outbreak is very, very serious in the performance of our rule of law. And we hope that can be improved in the future, because this is only 1 or 2 things among so many aspects of the quality of the rule of law. And quantitatively, Indonesia is the 3rd largest democracy in the world. Quantitatively, Indonesia is, if we include China, is also the 4th largest rule of law in the world. But the index until now is still 64, meaning there are so much thing we have to do to improve, the performance of our rule of law in Indonesia. Thank you.
And finally, Victor, in a couple of minutes, some of your reactions.
Between you and lunch, so can I just be very quick? As I've said on many occasions, I think we all agree the rule of law is precious, but it's also very delicate. And I think the events that we have witnessed over the pandemic, and I would definitely agree with that, is that by virtue of the pandemic, the challenges that has been created is unprecedented. And I think this partially explains the slip. But I think we are not in the same alone in this regard. As one Court of Appeal judge said to me when I was in London recently, he said, "You think you are falling apart? We are falling apart as well." our courts are literally falling apart, and we're 60 judges short in the Crown Court. So if we are to share lists of all the challenges we face, I think in many jurisdictions, you will see very similar items. And if I can just say, is really forum like this, which is, I find very meaningful, that we can actually talk about these common issues. So I've spoken a lot. Let me stop there. Thank you very much.
Thank you very much. Thank you, Victor, and thank you also for sponsoring this session. The Hong Kong Bar Association sponsored this session, so thank you. And just to summarize, I mean, we have heard some of the challenges that help a lot to contextualize some of the findings from the index, but we have heard as well just some possible solutions, and I will try to summarize some of what we have heard. I think Victor brought it very well. Just the rule of law just is something delicate, and something that we have seen in the index is that it's harder to build it than to erode it. So we have to be just careful and really aware when these things are happening. However, I think I would probably highlight 3 points that were given just by our speakers today. So one is the power of innovation that we're going to hear later today, just technology, digitalization, and so on, not only in courts, but in many different areas that can provide an avenue for strengthening the rule of law. The second one is institutional challenges. This is not simply about strengthening institutions, but also using institutions just to combat sometimes these erosions that we are seeing, and how the different constituencies can indeed use institutional challenges in many cases to challenge these. And the third one is that this is not simply something that it's in the realm of lawyers and judges, but that everyone is a stakeholder, and not only those in the government agencies, but even outside of government agencies. And we have heard the roles that both citizens, bar associations, and obviously just the different state institutions can play in this. So it's important to keep that in mind. So with that, I would like to thank you, everyone, for being here. Thank you to our panelists, both here and online. I'm sorry, Victor, that you couldn't come here, and we're going to have a lunch later. Thank you. Very good.
All right, ladies and gentlemen, Pa Alejandro Ponce, thank you so much for leading this panel discussion session. And to all panelists, we would like to address our highest gratitude as well. Distinguished ladies and gentlemen, we know that everyone's starting to feel famished. So this will be the lunch break. We have 60 minutes or 1 hour ahead. Please kindly return to the Istana Ballroom at 1 p.m. sharp. We're going to proceed to the interactive session later at 1 p.m. So ladies and gentlemen, please kindly enjoy the luncheon at the foyer of the Istana Ballroom. Bapak Ibu sekalian, ini saatnya makan siang. Kita punya 1 jam ke depan untuk istirahat makan siang. Makan siang sudah disediakan di area foyer di depan ballroom istana ini. Kita akan minta kesediaannya untuk kembali lagi bergabung di ballroom jam 1 siang tepat, di mana kita akan melanjutkan ke sesi interaktif nanti. Terima kasih. Give the biggest applause for the panel discussions of regional data from the 2022 WJP Rule of Law Index. I think the gentlemen were quite liking the stage. Thank you, panelists. Thank you, Mr. Moderator. Please be careful of your belonging as well during the lunch break. Multimedia team, photographer, media, international, national. Please kindly capture the moment. Okay, Mrs. Elizabeth Anderson, please kindly joining the panelists. Once again, the luncheon is prepared at the foyer area, exactly outside the Istana Ballroom venue. Bapak Ibu sekalian, makan siang dihidangkan di area foyer di depan area Istana Ballroom. Selamat menikmati dan sampai berjumpa di jam 1 siang nanti. Distinguished guests, ladies and gentlemen, welcome back. I hope everyone will supply with all of the delicious cuisines. During the luncheons, we would like to invite everyone to come back to the Istana Ballroom, Bapak Ibu sekalian. Saya harap semua sudah kenyang menikmati hidangan santap siang yang lezat sekali. Saya harap semua sudah kembali bergabung di ruangan ballroom Istana Sari Pasifik Jakarta. All right, so we're going to proceed. This would be the first interactive sessions. Ladies and gentlemen, I would like to kindly need your attentions. Bapak Ibu sekalian, boleh saya mohon perhatiannya? Thank you so much. Distinguished ladies and gentlemen, we are arriving at the first interactive sessions on judicial independence and the rule of law. For the first part, the session will present best practices and innovation presentations from Helen Burrows, the Director, International Program, Australian Federal Courts. We would like to present her video. Mrs. Helen Burrow already joining us online. We would like to ask the favor of the committee, the multimedia team.
It's a recording, and I think
pre-recording, Ibu.
I will make a few introductory remarks first, and then we will go to the video.
Yeah, I know, Bapak. All right, so do apologize, Ibu. So, ladies and gentlemen, this session will be led by our moderator, Ibu Elizabeth Anderson from WJP. Ibu, I give the session back to you. Thank you.
Good afternoon and welcome back to the Asia Pacific Justice Forum. I hope everyone had a good lunch and is energized for an interactive discussion about the challenges that we face in realizing judicial independence. We heard this morning an overview of the state of the rule of law globally and in this region with specific examples from a number of jurisdictions. Now in our subsequent sessions, we are going to dig into the specific issues that we've identified as priorities in this region and for this conference, starting with judicial independence. We heard a lot about this topic already this morning as a priority for many in this region. Judicial independence is, I think we can all agree, a cornerstone of the rule of law. I think it was Stephen Tiru who said this morning that whether we come from east, west, north, or south, we can all agree that judiciaries need to be independent of executive influence and control. And this is fundamental to realizing the rule of law and so much else that we seek through the rule of law. But what is judicial independence? It's a complex, multifaceted idea. Perhaps for framing our discussion this afternoon, I'll start with a definition from former Chief Justice of Tasmania, Sir Guy Green. And he defined judicial independence as the capacity of the courts to perform their constitutional function free from actual or apparent interference by, and to the extent that it is constitutionally possible, free from actual or apparent dependence upon any persons or institutions, including, in particular, the executive arm of government, over which they do not exercise direct control. This is a concept that has been developed quite helpfully through a number of standards from international organizations. The International Bar Association generated its minimum standards of judicial independence. The UN has promulgated principles on the independence of the judiciary. And of course, in this region, there have been important contributions to these norms as well. In 1995, 20 Chief Justices in the Asia Pacific signed a joint statement of principles of independence of the judiciary, and the Beijing Declaration or Principles. And these principles were later signed by 32 Chief Justices in Asia Pacific at Law Asia. And of course, we have the Bangalore Principles of Judicial Conduct, adopted in 2002. But much needs to be done still to implement these principles throughout this region and throughout the world. Judicial independence is one of those parts of the rule of law that we never fully achieve and we must always continue to work at. It is also not a standalone issue. It is deeply integrated with so many other parts of the rule of law. We cannot improve judicial independence if we cannot measure it as well. And so we will be speaking a little bit this afternoon about how it is that we can actually measure this complex idea. So in this session, we will break our discussion in two, and I want you all to get ready to participate. We will start, as our moderator was suggesting, with some examples of best practices. We have two recorded statements from colleagues working in different parts of the Asia region to advance the independence of the judiciary. And so I'll share their recorded statements and then invite those of you who may have good examples of effective ways of advancing judicial independence to chime in. And then I will invite an expert panel to join me on the dais up here to discuss this idea in greater detail and address some of the questions I've outlined here. What is judicial independence? What are the threats we see to it? And what are some of the ways that we might measure it and advance it? So with that introduction, let me turn first to a statement that we have prepared from the Australian Federal Courts, which has been very active in advancing judicial independence across the region. Helen Burrows, who's the Director of International Programs, has shared this brief statement about effective approaches to doing so that they have identified. Thank you.
Good afternoon, ladies and gentlemen, and greetings from Papua New Guinea. I'm very sorry I'm not able to be with you today. I am, though, honoured to share a brief overview about some of our work related to transparency and accountability. My name is Helen Burrows, and I am the Director of International Programs with the Federal Court of Australia. To promote transparency and accountability, the Federal Court has worked for many years with a number of judiciaries across Asia and the Pacific. While our work has been geographically broad, I will, though, confine this brief overview to a discussion of our collaborations with the Pacific over the past decade. In 2012, there was very little judicial and court data about the workload, productivity, and performance of courts across the Pacific region. and there was little understanding about how data about these facets of judicial administration could be used to improve it. Only one of our 14 partner courts was regularly producing an annual report that was publicly available, and no courts were reporting publicly on court performance standards and the extent to which they were being achieved. Acknowledging this reality, the Federal Court worked closely with the region's Chief Justices to develop a regionally tailored framework of indicators against which courts could strengthen accountability, transparency, and external dialogue, whilst also improving internal visibility of their court's performance and productivity. The framework of indicators became known as the Cook Island Indicators, and they comprise 15 measures. We also supported the development of court management and sustainable development goal indicators and reporting, but that's a story for another day. The process then to develop the Cook Island Indicators comprised drawing out the core elements of each court's mission and vision statements as reflective of the qualities considered to be integral to judicial functions. On behalf of the region's Chief Justices, we also spoke to key external stakeholders to identify the barriers they commonly faced in accessing formal courts. Then, building on good international practice, the region's Chief Justices identified the key themes of public accountability. They identified 5 thematic areas, namely case management, accessibility and affordability, feedback and complaints, human resources and transparency. Indicators to measure progress against these 5 themes were then developed, ensuring that they're relevant, appropriate, and could be measured by all the courts despite their differing systems and capacities. The 15 indicators were thus selected as representing the essential data that jurisdictions, whether large or small, should ideally have the capacity to collect, analyze, and present in their annual reports. A decade since commencing this journey, all 14 partner courts are producing annual reports and are reporting on an ever-increasing number of the 15 indicators. Perhaps more important and not immediately obvious from the quantitative changes are the underlying attitudinal shifts that have been seeded and supported. Understanding the need to be accountable to and collaborate with external stakeholders has grown considerably. The dialogue has transformed from a discussion regarding the justification for public reporting and accountability to discussion about how to effectively and reliably collect the data and thereafter analyze and present it simply, clearly, and accessibly in annual reports. The cumulative result, I'm very pleased to say, has been significant progress in transparency to the public, which has in turn promoted and improved public trust and confidence in Pacific courts and justice. While the pursuit of justice is a never-ending task among our courts, we congratulate our Pacific partners for the results they've achieved. And I thank you for listening to this brief presentation today. Enjoy the rest of your conference. Good day.
So thank you very much to Helen for that perspective on working with courts to both define and measure effectiveness. We'll hear now a recorded best practice from Miriam Chinapa, who has a very different approach reflecting more grassroots engagement in advancing independent judiciaries. Can I have the recording from Miriam, please?
Good afternoon, everyone. My name is Miriam Chinapa, and I'm a human rights lawyer and an international justice development expert. I must admit, I'm a little saddened that I'm not there in person, but at the same time, I'm delighted to have this opportunity to share best practices in this video presentation that I'm making from Brussels. In this session, I will specifically focus on Myanmar, where I provide leadership to a large-scale criminal justice program. I will share with you some of my experiences from the point of lawyers who persist relentlessly to provide early access to legal aid challenge arbitrary arrests and detention, and pursue with great determination the right to a fair trial and adherence to due process of law. As well documented by the Rule of Law Index for Myanmar, there is a rapid erosion of rule of law in this country. We are operating in a context where we often see the judiciary is compromised, laws are weaponized, and democratic institutions are gradually dismantled. Lawyers face security risks for carrying out the very basic professional duties. Speedy trials without respect for due process of law and premeditated judicial outcomes are sadly and unfortunately becoming a norm. In spite of this, Myanmar lawyers persist with the judiciary to uphold the rule of law as an independent basic value. Against this backdrop, what we know is that it is absolutely critical for lawyers to continue with the daily assertion of rule of law in courts, clutching to the hope that rule of law cannot be left to the absolute mercy of the state, which in Myanmar, the military-led government, without any redress in courts of law. With this firm belief and courage, lawyers have been able to go beyond the defeats and losses. And I would like to share with you some successes. For instance, a senior lawyer who practices in a very small town called Taungoo, which is about 90 kilometers from Yangon, managed to get the High Court to overturn a death sentence. She did this with meticulous preparation, mentoring from international and national colleagues, and above all, supported by an amazing community of pro bono lawyers who work in her jurisdiction. In another small town called Tonji, which is located in Shan State, lawyers there have been systematically drawing the attention of the courts through their criminal justice practice to the weaknesses and gaps in judicial interpretation of child rights law in Myanmar. Their persistence has resulted in courts issuing orders that align with the child rights law, such as forbidding the local police to detain children with adults and stopping children from being handcuffed by the police, and entrusting children to their parents or guardians for care and custody in the first instance when they come in contact with the criminal justice system. And what we also know is working in this context is that legal interventions must go beyond traditional lawyering to effectuate systemic change in the culture of courtroom practice, judicial interpretation of law, and administration of justice. Lawyers seek to instigate a narrative change in the courtroom where the voiceless, marginalized, indigent defendant clients get a platform to make their case, challenge rights violation, demand clarity and accountability from the judiciary. Another area of success we have seen is where lawyers have engaged with police and judiciary to provide information on the importance of early access to legal representation for criminal defendants, to educate them about the background of the case, discuss possible charges and options available for processing the case. And having had these conversations at the grassroots level and building their trust and confidence with justice actors, we have seen from our data that over the past 2 years, most of the legal aid referrals to the justice centers have been made by court clerks, followed by referrals from the police, and then civil society organizations. All this to mention that, of course, we do grapple with huge setbacks by engaging with the judiciary, not to mention security threats to lawyers for conducting cross-examinations of prosecution witnesses in sensitive cases or conducting defense-led investigations. there have been numerous occasions where our lawyers have been forced to withdraw representations due to security threats to their person or professional practice. And finally, our approach essentially has been one case at a time, which we find is particularly suited to Myanmar since formal paths to justice is often blocked. Through consistent capacity building, peer-led community of practice groups, mentoring sessions, providing robust security trainings, putting in place risk mitigation plans for lawyers, and above all, encouraging them to go beyond traditional lawyering. Our goal is not just to seek immediate results for clients, but also to effectuate a systemic change with the justice sector, including the judiciary. Thank you.
So that's a very interesting and I think helpful reminder that judiciaries can act independently, usually only when there are effective and courageous lawyers who are bringing cases to them that give them the opportunity to do so. So before we invite our expert panel to discuss the independence of the judiciary further, we've got a few minutes, and I'd like to invite any colleagues in the audience who have best practices or successes that they would, innovations in advancing the independence of the judiciary that they would like to briefly share with us. Do I have any colleagues? Prashant, I'm going to put you on the spot because I know you have a good example that you told me about over lunch, and maybe you can encourage others to step up.
Thank you, Betsy. In India, we have a strong judiciary. And one of the reasons for judiciary being strong is the appointment process to the constitutional courts, which are the high courts and the Supreme Court of India. So that happened through a succession of judgments by the Supreme Court itself. Because the constitutional provision provided for appointment by the president in consultation with the Chief Justice. But the government interpreted it as appointment by the government, and consultation with Chief Justice was not material. And once that trend set in, because after independence, the institutions were working fine. Later on, as authoritarianism increased, the governments wanted to push in the judges, which were according to their philosophy and in accordance with what the ruling party wanted. So the last onslaught came in the form of National Judicial Appointments Commission, in which a commission was formulated which had majority. It appeared to be independent, but the structure of the commission was that there will be 3 judges, there will be 2 eminent persons, and there will be the law minister. And now those 2 eminent persons could be handpicked by the government, because who will be the eminent person, that was not defined. So it is the bar associations which primarily were the petitioners to challenge the constitutional validity of such a structure. And the Constitution amendment itself required not only 2/3 majority of the parliament, but also ratification by half the federating units or the states assemblies. So, but in fact, on the floor of the House, it was passed with only 1 vote against. And it was also passed by more than 70% of the state assemblies. So from the legislative point of view, it was one of the most powerful legislations or amendment which had come forward. So when the case was heard before the Constitution bench, the hearing went for 45 days on trot during the summer vacation, so that other cases do not intervene. and I was the executive vice president of the Bar Association. So we were a group of 20 lawyers and others. And then we had almost 20 state governments and the union government against us. So the court invalidated the Judicial Appointment Commission, and it was declared unconstitutional. But this shows that, for the judicial independence, it is the lawyers organizations, civil society bodies who have to stand together. And here, even Bar Association of India, my own committee was divided. Most of our members were standing on the opposite side, but as an institution, we were standing with the judiciary because they happen to be advocate generals, they happen to be the law officers of either the government or engaged by the state governments as independent counsel. So this was a way where, the profession worked as an institution on one hand, as independent lawyers at one hand, but at the end of the day, the victory was independence of judiciary and through implication of the rule of law. Thank you.
Thank you very much, Prashant. Critical role for lawyers and bar associations, and also underscoring the importance of the appointment process to the independence of the judiciary. Are there any other examples that folks would like to share at this point? Okay. Well, be thinking about your observations, suggestions, innovations, and questions, because we'll turn back to the audience following the expert discussion. Would you like to introduce our panel?
Thank you very much, Mrs. Elizabeth Anderson. Ladies and gentlemen, we would like to ask the keynotes and invite our panelists for the interactive discussions. First of all, we would like to invite Bapak Laude M. Sharif, Executive Director of Kemitraan. Please kindly join Ibu Elizabeth on stage. Next would be Justice Shirani Tilaka Wardani, former Supreme Court Justice of Sri Lanka, member of Advisory Board, Judicial Integrity Network of ASEAN. Next panelist will be Pompen Kongkan Chankit, Executive Director, Cross Cultural Foundation, Thailand. Please kindly join the other panelists. All right, Mrs. Elizabeth Anderson, the stage is yours. Lead the sessions. Thank you.
Thank you very much, and welcome panelists and Justice Shirani on the screen who is beaming in to join us. Thank you for that. And Justice, perhaps we can talk to you because I know you have prepared a presentation with insights about judicial independence and particularly the way in which judiciaries can exert that independence in protecting the rights and interests of women and children. Justice, the floor is yours.
Myself? Okay, can you hear me?
Yes, now we can.
Okay, so I'm doing my own technology because they said for me to handle the technology. So please bear with me while I get my presentation up there. All right. So
have you ever wondered what it would be like to go to police station?
Yes, hello. So good afternoon. Today I speak as including how I've been introduced and my CV as the Deputy Chair of the Judicial Integrity Group, which created the core values of both the civil law countries and the Commonwealth countries and the Middle East, and formulated impartiality, integrity, equality, propriety, competence and diligence, and independence as the 6 core values that are part and parcel of the accepted norm of all judicial conduct. Now, though peace, justice, and strong institutions have been referred to in the UNDP Sustainable Development Goals, they have not given us a definition of independence. So I know you have been discussing this in the morning, and this will probably be just a summary of it. So what it says is judicial independence is more than a privilege or prerogative granted to the individual judge. It is instead an indisputable duty and responsibility imposed on each judge to enable adjudication of a dispute honestly and impartially on the basis of the law and untainted by external pressure and influence and without fear or interference. Now, the first one is, I've put it into 3 buckets: the party detachment, individual autonomy, and political insularity, which more and more is becoming extremely relevant and important. If you have read the recent article by Fareed Zakaria, the CNN correspondent, where he says and he was referring to the United States of America, that they have moved in a direction that has weakened its own legitimacy. It might be an occasion to begin a national conversation about what reforms could take place to make it less partisan, less divisive, and more trusted by the vast majority of citizens. But congratulations to the World Justice Project. You have gone beyond just a mere conversation. You have actually organized this wonderful conference, and thank you for inviting me. So judicial independence in the background of autocratization. And I'm saying this because we don't talk about it. We don't talk about politics in Asian region because everyone has a fear to talk about it. What I'm going to do is I'm going to talk a little about it, and then I will talk about my own independence, because I have lived in a country similar to yours where there are a lot of political issues we are talking about. And this narrative would not be authentic if we didn't actually have the fearlessness and the courage to speak about these things. The core of the principle of judicial independence is the complete liberty of the judge to hear and decide the cases that come before the court. Remember, no outsider, be it government, pressure groups, especially in this day of social media and other things, individual or even another judge should interfere or attempt to interfere with the way in which a judge conducts a case and makes a decision. Judicial independence is party detachment from the interested parties and stems from the values of impartiality and indisputable integrity. Judicial independence is also tied to the autonomy of judges. It refers to the conscience of the judge alone. As such, the independence of the judiciary requires independence as an institution from the other branches of the government as well as other judges. The influence arises in the form of collegial relationships and hierarchical influence among members of the judiciary. A judge might reach out to a colleague for a different perspective concerning a judgment or the doctrine of stare decisis. Further, both common and civil law countries, the higher the court the judge exercises control over their lower court colleagues through regular appellate procedures.
Justice, if I might interrupt you, could you click on your presentation to put it in presentation
I can,
mode?
but I'm worried I will lose you if I do that, because earlier when we were practicing, I lost you, but I will do it on request, okay? But if I lose you, give me 2 minutes and I'll come back.
We will wait for you, but it will help us see the slides better.
Yeah.
Perfect.
Okay, right.
It's perfect. Thank you.
Okay, so I'm having you in the middle of my screen, so I have to kind of lower you right down there. Okay, can you still see me?
We can see you and we can see your slides. Thank you.
Yeah, thank you. I just need to get the notification out of my way. So judicial independence is founded on judicial insularity, especially in cases, and this is as a judge and having worked with the judiciary and the court system for 47 years, especially in cases where a litigant is a state office and body, and I'm sure all of in the ASEAN region understands what I'm saying. The judiciary is tasked with the moral authority to not rely on the dialogical processes, but also on whether they are free, indeed substantively free from any political influence affected by the political atmosphere around them. Now I'm talking, this is a reported judgment and you can actually look into it. I have given the citation. This was a case where in the middle of the 1983 saw terrible racial riots in our country. And a fearless journalist took 9 photographs and his Associated Newspapers of Ceylon refused. He was working with them as a reporter, refused to publish them, but he published it. Despite not having the right to do so at the time, because there was the terrorism law, there were all kinds of gazette regulation curtailing the rights of this kind of information, because they felt at a time of the nation at that time, it would lead to a higher degree of violence between the races. When the appeal came before me, I remember considering the great effort and the risk on the part of the photographer, as these were captured on the unfolding of the communal riots in 1983. They were stark pictures. And I wrote a judgment in favor of the respondent, who was a reporter. Associated Newspapers was a government institution at that time. And I said this: a nation of people who make their life's choices on the information they receive from the media need to support and acknowledge their bravery and fearlessness, especially when they become independent monitors of power and the checks and balances in exposing the truth, thereby being a cornerstone in creating a fair society. So, okay, now I can't move this.
There's
Okay,
an
so
arrow. Is there an arrow button?
No. I'm on the PowerPoint. I can't move the PowerPoint, so I think I'm going to have to go to the end, the show, and use the. I can only move it if it's on this. Okay.
Okay.
So right. So in our country, there is the public interest doctrine. This came from the Justician Code, as you know, the rights of the right part of the sources of the Sri Lankan law, as in many countries in this region, is also the Roman Dutch law. And without having the right of life in our statutes, this was said where they use this doctrine of public interest. So this is not recorded as a statement of law, but in the new constitution that we're operating under now for the last so many years, is they brought it in as the doctrine of public interest, because we are a sovereignty lies with the people. And the other branches of the government, including the judiciary, when exercising it, should do it under the doctrine of public interest. And this said, the organs of state are guardians to whom the people have committed the care and preservation of the resources of the people. This accords not only with the scheme of government set out in the Constitution, but also with the high and enlightened conceptions of the duties of our rulers in the efficient management of resources in the process of development. So this was an important decision at the time, because it introduced the right to life, not through law, but through a decision of the court. Then there is another case, and I would like to speak about this case also, because these are showing you how a judge can put in the language into a judgment and thereby create law and thereby give leadership and thereby strengthen people. So this was a case, and I'm going to go through it very quickly because I'm conscious of my time, which was filed against the then president of the country. You know how all the judges in the room, you know how it happens when you get these, everybody's, waiting to see what are you going to say. And to me, it was just a case with litigant A and litigant B. The complaint was lodged against the acquisition of land on the premise that it would be utilized to serve a public purpose, which was knowingly deliberately and manipulatively sold to a private entrepreneur to serve as an exclusive golf club by the executive administrative action. The judgment was given by me in favor of the plaintiff, the defendant at the time being the president of Sri Lanka. You know, we have executive presidency, we have all this power there. In fact, they are the ones who appoint us to our position. And at that time, it is how does the judge, do you think, you know, I've always thought without fear, without favor, what does it really mean? It means courage. And I remember saying this, the president does not have the power to shield or coerce the action of state officials or agencies when such action is against the tenets of the Constitution or the public trust doctrine. It's very difficult to craft judgments like this. It's an enormous, it's a public litigation case. This poor man had just a few purchases in that land, and he was an executive president. And at that time, sitting down and I had to study, do an enormous amount of study, more in the crafting of the words. And I remember at one time saying about her generosity with public land, which were designed for public, the citizenry's use, that one could be generous if it was private land and give away a block of land, or in a burst of generosity, give away all your land if it is your private land. But when you are president of and holding powers which you have a duty of the public to act in a way that supports the doctrine of public trust, then you cannot have, because in that case, it came out during the facts that the commission had been paid to somebody to lobby with the president, a huge amount of money to lobby with the president to do this. And this was against the law. It did not matter whether it was, you know, some Joe or Jack or Haramanis, as we call, you know, the very president of the country. So my personal experience also I need to touch on. I was the first woman appointed in the Attorney General's department, first female in the High Court judge, the first female of the Court of Appeal, and the first female as president of the Court of Appeal. And I thought as such, in protecting the judicial independence and maintaining the judicial chamber in ways that do not thwart the independence of the judge can in fact create trust and confidence in the judiciary among the community it serves, and further cultivate a practice of good leadership among the legal community itself. Even the lawyers follow the leadership of the judge, which initiated from the bench. And I remember my early experience, it was 88, 89. There was a huge clash in the deep south. It was a turbulent time for Sri Lanka, which was steeped in violent political revolution known as the JVP insurrection. The southern strongholds, where I lived, almost 5 hours away drive from Colombo, and I lived there as a judicial officer, 2 small children, 1 8 and 1 4. And the fear, I had it. I was fearful. The violence, the unpredictability of the environment, in addition to the decrepit state of the courthouse at the time, did not absolve me from my duties, not only to make judgment, but also to exercise the leadership required for the smooth operation of the court. And what I wanted to do was show that whatever may be the outside or extraneous factors, my duty as a judge was to give the best judgment I could in the circumstances, following all the values in the Bangalore Principles, and that I can assure you with absolute sincerity that the quality of the judgments coming from such a muddy environment of violence, of corruption, of everything, did not detract from the quality of that judgment. And it was second to no court, even if that court was a designer court situated in the richest country of the world. The quality of justice did not deter. It was difficult, but I felt it was my duty, not just to give a judgment, but through that judgment, where every institution in the South was closed, to stand up and say, justice would not fail you. That was my personal experience. I thank you for listening to me. I have another case I hope I get the opportunity to speak to you about, where I differ, the only case in Sri Lanka where there is a dissent of 1:7, and that too was against a president. But if I'm asked the question, I will certainly talk about it. Thank you, Elizabeth, and thank you to the organizers for all what you have done. Thank you.
Thank you, Justice Shirani, for that really, truly inspiring account of your experience advancing independence in your role, and it underscored the importance of courage, of leadership, and the careful crafting of judicial opinions to exert independence effectively. I want to turn next to Pornpen for a very different perspective on some of these very same challenges. You have led a civil society organization working to advance rights and achieve the kinds of outcomes that you just heard from the justice there in a very challenging environment in Thailand. Share with us your perspective on judicial independence, the threats it faces, and some of the strategies that you have used to reinforce it.
Thank you very much. And I also prepare presentations, and I'm happy that I don't need to manage it myself. I think somebody would put it up. Okay, I'm coming from civil society, and thank you for the World Justice Project and also this forum that have allowed us as a civil society, maybe not that one. I can do that too. Can I? I'm coming from civil society. I'm a human rights activist, and later I study law and now become a practicing lawyer. And when one of very first case I assisted has won in the court on torture victims, and we're very happy on that case where the 13 years after the suffocation by plastic bag over a young boy, he was suffer from PTSD, and the family trying so hard to get justice. And 13 years after, the civil court have ordered some compensation. But it's not because of independence of judiciary. It was because of one video clip that had happened to leak out from police themselves in another case. So by then, the scene that no one ever seen that the police in Thailand using plastic bag is real. It's happened in front of 70 million people. And of course, it's accepted by the judge that lender quite big number of compensation to that young boy, but he still suffer from PTSD. I hope you can follow that case. Otherwise, if no presentation, I can go on with my note. Okay, I'm putting my first presentation as Thai Judiciary 101. In order to make everyone understand that Thailand actually have facing misinformation. Oh, I got it now. Okay. I think we have made some misinformation about our country. And this is Judiciary 101 that I want to tell you about. We have a reform of our judiciary 100 years ago when we are under the Rama V. And then after that, we have some kind of revolution in 1932, where we have changed the system from absolute monarchy to constitutional monarchy. And from then, there are some reform, but not the major reform. Until we have the People Revolution in 1997, and the Constitution at that time actually strengthened the principle, very basic principle, the separation of power. So the Court of Office have actually separated from Ministry of Justice. So we can then learn about the independence of judiciary through that reform in 1997 or around that time. But we are facing many coup d'etats, as you know. When we have coup d'etat, there is new constitutions. So we have changing our constitutions and the principle of independency of the judiciaries and other political and judiciary reform and other reform is rewritten all the time. But we don't have changed our military roles and also abusive police forces, including we also did not really have a kind of independent judiciaries being seen by the people, because we have quite small number, let's say, of human rights lawyers in our history, until I think we have more and more people after the transitions, which I would say the big transition is when the past king passed in 3 years ago. So when we have the Rama 10, there is a big reform in our judiciaries. One of the sample, if you see in the small picture, you can see that we're putting up photo of Lama 9 always in the courtroom. But when we have Lama 10s, no one has made the decision how are we going to put Lama 9 photos. So the court, I don't know who decided that, but then we have 2 kings picture in the courtrooms. That one of the transitions. And the photo that, the next one is our former Supreme Court judge was paying respect to the new king. So when the transition is right, we will get the advancement. But let's see. So basically, we have Court of Justice, we also have Administrative Court, and we also have Constitutional Court, and we have Military Court. So these 4 court function is in Thailand with the big buildings, with a lot of good presentations, a lot of advancements. And we also develop a lot of special courts, like the Environmental Unit, Juvenile Court, Intellectual Property, Consumer Court. Next slide, please. So this is one of my summary of my talk. I think our court is competent. We have very difficult examination for the lawyer, for the judges, for the prosecutor, and this examination has actually making a lot of rule of law principle within our law, within the practices. But when we're talking about impartiality and independency, I think we need some reforms from that. Whether our court is reviewing the state conduct, I can give you a lot of examples that they did not actually do that. So our very first ruling after the people, so you need a lot of extraordinary power, including video clip I said, so we won the case. Whether, when we ask whether we have judicial oversight or review, I'm very happy to hear our friend from Commonwealth Bar Association that you actually visiting each other and talking among each other and sort of something oversight. But we do oversight, they do oversight to each other. So we have First Court, we have Appeal Court, we have Supreme Court. That is oversight. Only that what we have. There is no other oversight body within our judiciary. We have one judge who committed suicide in the court of Yala in the southern of Thailand. He has made that big protest because his verdict on the southern separatist case was rewritten by his boss, and he was not agreed. So he shot himself in the court. But actually the bullet was missed, so he did not die in the court, but later he was also committed suicide. because of the oversight within their own institution, came out that he had mental problems. Okay, so all above that, whether our judiciary is upholding rule of law. I would say yes, still we have some good judgments. We got some remedy, we got some reparation, some perpetrator gone to justice, go to jail. We have the biggest prison population in Southeast Asia, in the world also, number 6. That means we get a lot of perpetrators to jail. But with the respect to the free trial principles, especially the case that have policy-driven court cases, I would just name some. War on drug, war on terror, war on terrorists, separatist movement in the southern conflict, not to say about lèse majesté, you cannot comment on the monarchy case, political cases, and land dispute cases, especially for indigenous people or people who are living in the forest. All these cases, we can have a big question about fair trial principle and other right to defense, because the law practices has been framed for the policy directive. Third one, we also try some of the civilian in the military court after the coup d'etat, and it's just stopped in 2017. Next slide, please. I will be quick because it's recorded. We have some certain political violence, human rights violations that are not respond by our rule of law principle of fair trials by our Thai judiciaries. So 99 people were shot dead on the street in 2010. No one have been brought to justice. We have a continuous conflict, armed conflict in the Deep South since 2004 until the present time. 7,000 people killed, 200 something extrajudicial killings, including that incident of Tak Bai, where 78 people died from suffocation. None of any officer are brought to justice. A lot of big compensation though. We have a lot of cash compensation to pay off from our own tax, but no justice deliver. Next one, please. So now some priority that I think we need. The first thing, I think we need human rights educations at all levels in our curriculums, because human rights was not very friendly topics in many conversations. At least we would like our children to learn from the very beginning. The second is the reform of the lawyers, not the law. Lawyer, judges, prosecutor, and to make their educations, their examinations, and probably do something with election. I don't know whether we can go that far, but we need some kind of accountable to public for those judges. The third priority that I think we needed is we need the promotion or supporting of the right to defense. I think we have a small number of human rights lawyers, and we have 300,000 or more military who have also the power to arrest and interfering with our justice. We also have 200,000 police. We don't have enough lawyers and human rights activists to defend for the people who are affected from that abuse of power. Legal aid. Legal aid is also important. And also we also need the social justice legal aid. That means it's not expensive to hire a lawyer in Bangkok or in Thailand, but we need some kind of human rights and social justice lawyer. The fifth one is prohibition of the evidence obtaining by torture. a lot of law of evidence was not respected in a number of cases, like war on drug, war on terror, and also about separatists. So if the torture still, torture, evidence obtained by torture or ill treatment still admissible in the court, the torture continue, and we will never ever get justice on those cases. And the sixth one, I would invite everyone here to go to Thai court when you go to Bangkok or go to Thailand. After the beaches, after the mountains, after the food, go to one of the courtroom, okay? Any courtroom is open for public. However, you may not cross your leg because your leg will point it to the king's photos. You cannot take notes. In some courtroom, they allow you to take notes. But for political cases, for a very high-profile cases, you cannot take notes. No slippers, because the slipper can throw to the judges too easily. So the slipper is outside. Sometimes the translation is not even allowed because the voice, the sound of English is or other languages is obstructing the justice. Thank you very much.
Thank you very much, Pornpen. Really interesting and provocative summary of the challenges that you have been facing and some really important suggestions for how the situation can be improved. Lauda, let me turn to you now and get the perspective from Indonesia and the challenges that you have seen here to the independence of the judiciary and some of the ideas that you have for addressing those challenges.
Thank you very much. I never been a judge. I teach judge sometimes, my judges, but I never been a judge myself. So because I'm representing, I'm not representing, but we swap a position with Professor Al-Siddiqui and the former Chief Justice of the Indonesian Constitutional Court. So instead, I'll be talking about a little bit of footnote of the Indonesian rule of law, and also some part of it about the independency of Indonesian court. If you can actually share my slide, actually I have it. But I think before that, I think I want to present this maybe like 5 or 6 minutes. I try to continue echoing what actually Stephen Thiru just mentioned and this morning, that 2002, 2021, it is different from previous years because of the COVID. Let me give you for the next slide, to give you a perspective from Indonesia, the COVID-19 and government emergency legal response. Next, for example. Yes, once the COVID coming, the president issue government regulation in lieu for law, then become a law in 2020. My former office, Corruption Education Commission, issued circular letters allowing government officials to receive donation, which is in the past, it is haram or prohibited in Islam. And the next one, National Procurement Agency, for example, issued circular letters allowing direct appointment for government projects. Once I see this, I wrote it in Kompas Daily, the main newspapers here in Indonesia, and I say how to save the COVID fund. Next. Yes, if you look at the anatomy of the law itself in relating to the COVID law, the emergency law. Next. For example, you will find some article which is actually, it is contradictory with the idea of good governance. For example, in order to implement the state financial policy, for example, the government has the authority to make an adjustment of the amount of mandatory spending, make budget shift, without any consultation with Parliament. For example. So easy. The next, for example, yeah, it is also created one particular article said the cost incurred by the government to support COVID-19 program cannot be considered as state loss if something actually lost. So it is. So when I saw this, my KPK antenna it just become like wing. So that's why I wrote it in Compass. Next, let's go next. So I'm not actually predicting we are going to arrest the minister, but that's what really happened. They manipulate all the COVID money and end up with the KPK arrested the Minister of Social Affairs because he manipulating all COVID. But not only him. From the central, provincial, district, up to the local level. And according to my reading, not only in Indonesia, in many other countries in the world. So that's why the declining of World Justice Project Index can be, I don't want to understand it, but can be understood. Next. Next slide. Now, I want to concentrate on this because this is very, very important. On the index, the government constraint it is blue for Indonesia. But to tell you the truth, never in the history of Indonesia, the former justice accused lawmaker of violating constitution. Jokowi, the president, gives nod to controversial removal of constitutional justice. This is against the constitution, I think, as a lawyers, and also against the law of constitutional court. They just removed one of the justices of constitutional court just a few weeks ago. Of course, maybe not yet included in the index for 2022. Next, for example, this is also important, the new development of police and criminal justice, because one of the main actually law enforcement agency that actually need a special attention, it is the police itself. This particular case actually has opened up a lot of problem inside the Indonesian National Police. This is actually a general in the police, actually killing one of the police. And since then, we knew actually now we would have a 303 consortium. This is rumors. That's why I have to be, self-censorship is important now in Indonesia, which is actually never happened before. So that's why it is not me saying it, that's the copy of the Jakarta Post. So you cannot blame me, but I mean, so this is the Jakarta Post, a copy of it. For example, the consortium of 303, it is actually, according to the rumors that some high-ranking official of the police actually have a consortium protecting online gambling. It is interesting. 303, it is an article in our criminal code prohibiting gambling. So they make the name of the consortium 303 Consortium. Next. Based on that, actually, if you look at the independency of the Indonesian court, the removal of Indonesian constitutional court, this never happened before, and the public discussion of internal problem is now become a public domain, and I do really, really hope we will not continue this trend. Lastly, as a final conclusions of my and responding to friend from Thailand, one of the way to try to limit corruption within the court in Indonesia, long time ago, not long time ago, but like more than 10 years ago, we introduced the KPK and the Supreme Court agree to have video recording in every court in Indonesia. And it was actually recorded by the law students in many provincial law students, and it still continue. So there was a change on the behaviors of the judges, and you make basically we record every movement of the court during a proceeding. For the first time, it was only 4 corruption cases, but it is actually expanded for other cases. And I hope I'll come to Thailand court. I will not cross my leg, but I bring my camera. Thank you so much.
Excellent. Thank you very much. Underscoring some additional important points, in particular, the challenge but importance of taking this highly technical, complicated idea of judicial independence and translating it for public consumption and building constituencies in the public for it. So I have lots more questions. I'd like to do another round, but I want to take a moment and invite members of our audience to join in the conversation and pose any questions to our panelists, including Justice Shirane on the screen. And yes, is there a microphone that can be passed there? Yes, thank you. Can you introduce yourself, your name and affiliation?
Thank you. Assalamualaikum warahmatullahi wabarakatuh. Izinkanlah saya berbicara dalam bahasa Indonesia. Saya ingin bertanya pada Pak, siapa tadi pembicara terakhir? Pak Laude ya? Pak, mohon maaf Pak. Memang sudah hebat Pak. KPK sudah bisa mampu menangkap menteri di kabinet saat ini. Sudah bisa menangkap jenderal polisi. Tapi dalam hal pengadilan itu tidak pernah bisa dibaca oleh masyarakat. Masyarakat awam seperti saya ini Pak. Apakah itu memang sengaja pengadilannya tertutup atau gimana Pak? Supaya hukumnya ringan Pak. Yang pertama. Yang kedua, saya usulkan Pak supaya KPK cobalah Pak buat penangkalan buaya Pak. Kenapa? Untuk para koruptor yang sudah mencapai di atas 10% hukum mati, masuklah ke itu penangkalan buaya Pak. Terima kasih.
Saya kurang dengar. Pertanyaannya tadi apa? Tangkap apa?
Yang terakhir Pak ya?
Ya, pertama juga.
Pertama jelas. Tadi dalam hal penangkapan para koruptor hebat, sudah bisa menangkap seorang menteri, bahkan jenderal polisi. Tapi dalam hal pengadilan tidak pernah terbaca.
Belum
seperti
pernah.
apa?
Oke.
Dan mungkin apakah ini untuk supaya ringan hukumannya. Yang kedua, saya usulkan supaya KPK coba membuat penangkalan buaya. Bagi yang koruptor di atas 10 miliar, masuk aja ke situ. Penangkalan buaya tadi kan nanti akan kapok orang melakukan itu. Akan mikir 1000 kali. Terima kasih.
Yeah, Laude, would you mind summarizing the question briefly in English so that Justice
Okay,
Shirane-
and he said that the KPK in the past has been actually caught red-handed, the minister or even high-ranking police officer, but never judge. And the second question was, maybe it is good to have like crocodile farming, and if KPK actually caught corruptors, then they can just feed it to the crocodile. So, saya jawab pertama bahwa banyak juga hakim yang ditangkap. Bahkan barusan barusan 2 minggu, 3 minggu yang lalu, Hakim Agung ditangkap, dan yang satu lagi Hakim Agung ditetapkan tersangka. And one of the justice that actually charged now, it is very dear friend of mine. Actually, she's 2 years younger than myself. We came from the same law school. And he used to be good activist in the past, but people change. So, yeah. In relation to kebun buaya, Pak, saya tidak setuju. Saya tidak setuju. Tapi saya bisa paham mengapa Anda frustrasi seperti itu. Terima kasih.
All right, let me take maybe 3 questions and then circle back to our panel. So back there on the left, and then back there on the right, and then there was one up here, I think, someone. So back there. Put your hand up high and yes, sir. Can somebody get him yeah.
Thank you. My name is Emmanuel. I'm from IDS Law Firm in Jakarta. My question is to all panelists. My question is, do you see strong correlations between the economic stature of a country with the quality of judicial independence? In the sense of whether the wealthier the country, the better the quality of the judicial independence. And this is from the sense of allocation of state budget to funding the judiciary. So that's the first question. And the second question, which one do you think is better? To fund the judiciary mostly from the tax, means from the state budget, or through the court fees? Because I believe, good judiciary needs lots of funding. Poor judiciary will be poorly funded because of low quality of the judges and low quality of the court itself. So that's my question, if you get it. Thank you.
Let's capture several questions, and then yes, back there, yes.
Thank you. My name is Ningrum Sirait, and I'm an academic. I have curiosity about how each jurisdiction who just presented just now tried to do the oversight. It's almost clear that the Supreme Court, as the highest court that we believe, live in a very closed bunker, I may say. We don't know what's happened because the oversight is always conducted on the lower courts, and it's been exposed to all media. But I don't see any, sharp strategy on how Supreme Court in all jurisdictions try to prove that they also, are running their independence, like the former justice from the Sri Lanka, keep saying that, oh, I'm independent, I'm not distracted by all aspects. But the people outside the court, seeing is believing, is not being, is believing is seeing. Until one get captured, and we thought, okay, the true fact is you're not as clear as you keep saying or keep trying to prove. So I'm curious to see what is actually the best strategy to prove to the court, to the people that, hey, we're a very noble institution, and it's not through the decisions per se, but it's through our behavior and what we are doing in the real world. So that the questions to all of the panelists. Thank you.
Thank you very much. Okay, one more. Yes, here.
Thank you. I'm Somsi from Union for Civil Liberty, Thailand. I have 3 questions. First is about how I just would like to ask Mr. Roth. Yeah, the speaker. What is the process to be the judge, primary court judge, appeal judge, and the supreme judge, or to be the chief of the Supreme Court? That is the first question. I mean, after the examination, of course, you have examination, and who endorse the judge? I mean, in all level, no? Second is that because in my country to review the case after the judge give verdict to the case, and then if we find the new evidence or the witness, we want to review or revival the case. Can we do that easily? The third is about, can people criticize or put comment to the verdict of the judge? You understand my question? So, because in my country it's very difficult to criticize or put comment to the verdict of the judge. The judge should be the final decision. No one can touch it. So you have to agree, you have to obey with the verdict. Okay, thank you very much.
Okay, I think I got them. I will try to summarize the questions and farm them out to our panelists. And I'll take maybe the first one for myself, and that is the question about correlation between economic development and judicial independence. And this is something that you can interrogate looking at the World Justice Project Rule of Law Index, where there are some measures of the independence of the judiciary, the role of the judiciary as a constraint on executive power, for example, the impartiality of judicial decision-making in the index. And you can look at that data, we organize it by country, and then you can look at it in income groups. So the richest countries, the middle income, low income countries. And while there is some correlation overall between, and quite powerful correlation between economic development and rule of law as a whole, I think that you will find much more variation on certain sub-factors like judicial independence, where there may be some quite wealthy countries that do not have an independent judiciary in those measures. So I'd encourage you to look at that data. Your second question was about the funding of judiciaries from state budget versus court fees. I think it's a really interesting question. And we also had a question over here about the best way of exercising oversight of courts, particularly high courts, and proving to the people that they are independent. And maybe I can suggest both of those questions could be put to you, Justice Shirani.
Yes, I like the commentary, and I don't know whether you captured that in what you say, how every judge says. I think it is Banasa's question. Every judge says, oh, we are full of integrity, we are honest, we are this. But I think the proof of the pudding is eating it. You know, that is why I chose judgments. And actually, if I'm given the time, Elizabeth, I have a very important thing to talk to you about what has happened. And it's difficult to believe it would happen in a country like ours. So there was this judgment where I dissented. It is the first dissent in the history of the country that has ever in our history, where I dissented. It was a 7-bench, and I was the sole dissent. It was about a very powerful president who is very autocratic, and I think you know who I'm speaking about, but I want to make it larger than him. It was, and so it was about a person who admitted his corruption, and he filed an affidavit agreeing that he was corrupt and agreed to leave his position to the Supreme Court. Then this very powerful president, executive president, was re-elected. When he was re-elected, and I'm giving you this especially for you to know that there are judges who are really putting themselves out there. You know, we lost so much of our promotions. I ended up only as the acting Chief Justice. I lost 3 promotions because I held against almost every president in my country. And that is recorded. It's in the law reports. So when this case came up, 6 of the 7 judges said, a president is a president, he can do anything. And he had wanted to remove a 1 paragraph from an affidavit where he said he's giving up his position. And one of the arguments was, well, if the president wants it, it can happen. And I gave 2 pages completely criticizing that argument, saying that this is a democracy, it's not an autocracy, speaking about the powers and being openly critical. Now, I gave the judgment. I used the font of Calibri. We didn't have it in our court system at that time because I was very computer literate even then. And I downloaded it from the net and I wrote it. Now, I signed the copies, which was for the court record, and they issued, and I put it on a pen drive and I gave the copies to be made because the journalists are waiting. They grab it and they ran. What they had done was increased the size of the font, removed the 2 pages which I had spoken so harshly about an incumbent president. And I was at the juncture of my career where I was about to be made Chief Justice. And just shortly before that, I gave this decision. And it didn't matter because, I don't know what your religion is, but I am a Christian. And to me, it is a divine thing to give judgment. It is, we do it with greater powers. So can you imagine, I was in my chamber and I had the courage to read out those 2 pages. And the 6 judges were squirming and they were furious. I mean, you get pressure from within the judiciary, and that's the point I'm first of all making. When you talk different, when you act different, there's tremendous pressure from within the judiciary. They didn't even talk to me for some time. So I gave this decision, and somebody called me and said, look, the judgment that is coming out is not the judgment that you gave. So they came rushing up to me and I just said, okay, and they said, look, I'm sending it to you on a fax. I opened it and these 2 pages were missing. Now this is a certified copy issued to the journalists. They took the copy and they rushed. That's how journalists rush to publish. So I went through it. I immediately called the registrar, who's the chief person who issues this. And she said, no, I just gave this to one of the junior officers because it was only copies. I said, no, please look at this. The font is different. My signature, which was on half the page, was in Calibri. The rest was different. They took the pages and they ran off. And then she immediately issued a second certified copy. Have you ever heard in the Supreme Court 2 copies of one judgment being issued? Now, that was not all. So then, of course, all the journalists started calling me. And I just sat and I thought of the repercussion on the Supreme Court. And I told them, yes, it will be Sunday's headlines, but they will be dancing on the grave of the Supreme Court after that. And I thought it ended with that. But today, if you Google anywhere, you will not get the dissent judgment. Not in the law reports, not anywhere. What has happened to my dissent? So if you can find it on the regular thing, but I am going to, and I'd like to share screen on this, right? Would you give me share screen? Okay,
sure.
On that. Yeah, so I'm going to give you the reference so that this lady particularly can see how important this is. Please take this. I've given you 2 citations and take it and refer, and you will be amazed because what they say, I think the person who reported is this guy called Nihat.
Be able to get justice because you are considered credible.
Sorry?
Can you imagine how you can live in society with a bank account? Because you can open one with a legal capacity. How
I can't hear you clearly.
A court or lawyer, but not understanding it. How would you feel knowing people might see you as an easy target?
Oh yeah. I mean, I served it. Oh yeah, I have given.
How they ever punish? This is a especially frightening as a woman.
Yeah,
I'm not sure who's speaking right now. Is it somebody who?
Everyone.
It's somebody who is on our online audience, I think perhaps is speaking.
Yeah, and she was saying, how do I do it? When I took the post, I was the first woman and I was determined not to fail because I wanted other women to follow me. So there was that pride in my work, and I work hard. And I think when you are deeply Your values are very strong and not built it is on a different level, because I worked in the JVP going up and down. I would look at my children and think, when I'm waving goodbye, this is the last time they're going to see their mom, and I'm going to wave to them and smile at them. Because there was there were executions that were being done. So I've been threatened many times. If you see the criminal law reports, a judge was killed and the final decision was given by me. And in it, I have dealt with every aspect of it. And the person who was convicted was the greatest drug dealer in the country. And he had threatened to kill. I mean, he was sending threats even long after I left the judiciary. He died of COVID. So, I feel there is some hand that is protecting me. But in this judgment, even today, imagine, and there is a deafening sound of silence. Please read this. Take this and read it. And now this is by Nihal Sri Amarsekar, who exposes corruption. I can publish it in the newspaper, but what is the point? I did all I can and I moved forward. And that is what I'm telling all you judges who are there. Yes, we are living in this difficult society, but I felt we were at a juncture with an autocratic executive president, and the right thing for the nation, the right thing in everything I held sacred, the right thing in following the principles that govern my job. I had no choice. Every time I found that when I look back on my life, I was overlooked. It was the best part of my career. There was so much of fun things that happened in my life during that period. So I want to encourage the younger judges. Yes, they can take my life again. But I believe, and I remember driving leaving my house and driving into the JVP. It was not easy. There were 3 men who were appointed with me and they all got safe jobs. I was the woman sent out there and they thought I could never do it. So it's a challenge. It's a wonderful challenge to be protected, to be strong, to be different, but plenty of study. You work 10 times more than anybody does because you believe. Don't you believe in something even in this awful world that is around? Okay, so if it's costing me the Chief Justiceship, or if it's costing me a promotion, so what? That was not what I came for. I came to serve as a judge. And to me, the lodestar of independence is equality to all. Difference should not disadvantage. And that is why I work so hard, working with child rights, women's rights, because I see the disadvantages in difference and the insularity of every national and international law through culture, custom, and religion. Yeah, though people are insulated, what is the point of developing all this? Because internally, we have cultural beliefs, we have religious beliefs, but the status of women are diminished. And this is in the law, it is in every judge who sits on the bench. That is why we need to sensitize, educate judges, and to remember that we are who we are because we are in leadership positions. And that is not a chain to be worn, a glamorous necklace or something. It is a place of power where we extend a hand to the inequalities there and give them the power through the courts to be on an equal playing field. That is what the law says. Equality of all, to all. That is not what's happening. That is theoretical equality. The day it becomes substantive equality and all people are treated equal before the law. And that is why I'm so interested in this. Because at the root of independence is equality to all, without favor, without fear. So how can you ask me the question, did I have the courage? I signed on to that contract. That is my lodestar. So the lady who spoke, do you understand what I am saying? If I can't do it, I must give up my jobs and its perks and leave. And the guy who spoke about economy, my goodness, I worked in a courthouse down south where my roof was leaking. I will give you every one of my judgments. You analyze it and you will see that the quality of justice does not change just because of extraneous factors. We may go even into worse times, but just imagine being a judge who stand up for your nation because you are the last voice left. And if you want legitimacy as a judge, this is what you should be doing. It is a duty. It is indisputable integrity, which every judge must do. I can speak like this because my judgments support me. So please take this. Go back and read what happened. That's the reality. Even today, it's not in any, you can't access my dissent. The other judge's assent is there. Case is reported. my dissent is not, unless I think there's some private law, something which has it. But this is put in, I think, by somebody who was analyzing corruption in the courts, and he gave this website. Please do me the favor of going through it and read what I have said. And this lady, this Banaza, please, Bahasa, am I getting her name right? Please read this. You know, what I have said against the president, every bit as hard and as strong as the presidents you all are talking about, in a system which supported every act that he did. And I'm quite sure at the end of the day, they too respect you for your independence. I mean, what could they do? Shoot me, kill me? I used to look back, as I told you, traveling to my first station and say, Lord, you can look after them far better than I can ever look after them. Hand it over. Because there's, nature has its protection. The divine has its protection. Thank you. I spoke a lot, and I'm sorry about taking it so long.
It's okay, Justice Shirani. It was certainly inspiring to hear. I'm going to take away from today, the lodestar is independence, and we should all cling to that, I think. There were additional questions here from our colleague from Thailand, but they're quite technical and specific. I might suggest that over the coffee break, Laude, you can field those questions directly. And 30 seconds each of you, and then we'll get to coffee.
Thank you from Thailand. How to become a judge in Indonesia. After you finish law degree, you apply to become a judge. Usually, it is actually they open up the application, and you become a judge for the lower court. Usually, you have to go through training for 1 year before become a real judge. For the Supreme Court justice, it is actually open. You have to go through the Judicial Commission. They open up the positions, and some of them actually came from career judge, and some of them actually from outside lawyers, professors, who understand law. They must have law degree, can be become judge. Another one, if there is a new evidence, can be retried. Yes, based on the Indonesian law, we can actually, if we get a new novum, then we can actually apply for the retrial. The next one, whether we can criticize the wording of the judge. Yes, we can. I think as a lecturer, we have to be able to do that. Otherwise,
we cannot.
We can criticize the wording of the decision of the judge, even the Chief Justice himself. We can criticize it.
Thank you very much.
Yes, can you show the last slide, please? Just the last one. I really want to show the last slide of my presentations. It's about the democratic youth activists in Myanmar is about to be excluded by the judgment of the military, I don't know, it's military court or the civilian court. Yes. So please don't forget what is happening in Myanmar. I think the position of our friend who mentioned about the advancements of the cases in Chan State is very good that individual lawyer and the group of lawyers can do that so. But now there is a lot of attempt to kill a lot of activists by making it as a judgment in Myanmar. Thank you very much and enjoy your coffee break.
Thank you, Pornpen, and thank you to all of our panelists for this really inspiring panel that reminds us of how important the independence of the judiciary is to human rights and to realization of so much of the rule of law. I'll turn it over to our moderator to tell us where we go for coffee and when we reconvene.
Thank you very much, Mrs. Elizabeth Anderson, as our moderator for this interactive session on judicial independence and the rule of law. Thank you so much for Bapak Laude Ahmad Sharif as Executive Director of Kemitraan. And also thank you so much for Justice Shirani Tilaka Wardani for joining us online, and to Mrs. Pompan, Kong Kanchon Kit, Executive Director, Cross Cultural Foundation, Thailand. Ladies and gentlemen, without further delay, we're going to have coffee break for 20 minutes ahead. And please kindly enjoy your tea, coffee, and snack. It's ready prepared and also provide at the foyer area. Please kindly return to the Istana Ballroom for the next 20 minutes as we would like to proceed to the next presentations. Bapak Ibu sekalian, kita akan melakukan sesi coffee break sejenak selama 20 menit ke depan. Silakan menikmati.
Miss Malati, I'm Shirani Tilakavardhana, Justice Tilakavardhana. May I sign out now because this was
yes. Hello, Justice
You have
Shirani.
no problem. So thank you. You did a wonderful job of comparing.
Thank you so much.
Very
Highest
much.
gratitude. It's an honor and pleasure, Justice.
Thank you.
See
Bye-bye.
you soon. Goodbye, Justice. Thank you so much. Hadirin sekalian, baru saja Ibu Justice Shirani minta izin untuk meninggalkan Zoom floor. Mungkin bisa dibantu oleh tim teknis dari Bahasa Global. Terima kasih Bapak dan Ibu. Kami minta kesediaannya untuk kembali ke Istana Ballroom 20 menit ke depan. Selamat menikmati teh, kopi, dan snack yang sudah disediakan di area foyer. Terima kasih. Distinguished guests, ladies and gentlemen, we would like to invite everyone to return to the Istana Ballroom. We would like to proceed to the next sessions. Bapak dan Ibu, para partisipan, kami minta kesediaannya untuk bergabung kembali di Istana Ballroom. Kita akan lanjut ke sesi berikutnya. Terima kasih. Dearest participants, they're still located at the foyer enjoying the coffee break. We would like to ask for your keenness to kindly return to your seat. And together with us in the Istana Ballroom, we would like to proceed to the next sessions. Thank you very much. Distinguished participant, this would be the third calling. Do apologize, but we would like to make the timing still punctual. Please kindly return to your seat and joining us together in the Istana Ballroom, we will proceed to the next sessions. Bapak Ibu sekalian, kami mohon kesediaannya untuk segera bergabung kembali di Istana Ballroom. Kita akan melanjutkan ke sesi presentasi berikutnya. Terima kasih. Ladies and gentlemen, the fourth calling, I think it will be the last calling of the day. Please kindly keen to return to your seat and joining us together in the Istana Ballroom. We will proceed to the next presentation session of the day. To all committee, please kindly also keen to help to check whether we still have participants that still located at the foyer area to kindly join us back in the ballroom. Ladies and gentlemen, this would be one of insightful moment of the first day of the forum. We will proceed to the next sessions, which is the presentations on how technology can strengthen access to justice by Jupitis, a justice technology company in India. This presentation will be delivered by the founder and the CEO of Jupitis, Mr. Raman Agarwal. Please kindly lead the sessions. Mr. Raman, please give a warm applause, ladies and gentlemen.
Good afternoon to everyone, and I'm very privileged to be part of Asian Pacific Justice Forum, and thank you very much. I am just taking you a little away from what we have been hearing in the past sessions, and I would like to give little introduction. My name is Raman Agarwal. I am CEO and founder of Jupitis Justice Technologies Private Limited, and this is basically is the first justice technology company in the world which has developed next generation technology for the justice sector for civil and commercial disputes. So I'm finding the technology is one of the best means and ways to resolve the disputes across the globe. So after spending 4 years in this area doing research, conceptualizing, designing, developing, we implemented this technology starting from India, and that was introduced last year around September and October. So I'm giving you presentations on the justice technology. So we are world first justice platform. And over to next slide, please. So Jupitis has developed a system which is basically support all the dispute resolution mechanism, whether it is a judicial mechanism, whether it is a quasi-judicial mechanism, whether it is an ADR mechanism. So everybody thinks that justice is a culmination of a law, but I feel that justice can also be delivered not only through the articulation of law, it can also be delivered through the other means like settlement, mutual settlement, and etc. So what we did, we have created a new space called Just Tech. So I'm not saying that it is a legal tech, because the Just Tech is a wider term that also includes the legal means to resolve the disputes. So that technology has been developed by adopting an enterprise architecture. Yeah. So next slide, please. So I'm just giving a little background, which have always been part of our governing principles or the motivation to work more and more on the evolving needs of the justice system in the world. Next slide, please. The first is the lack of access to the justice. Over 5.1 billion people have no access or not getting justice for their daily needs or everyday needs and the severe justices. So you can understand from this problem, even in India, one of the latest report from our planning commission, that 40 million cases are not brought to the court per month. So you can see the kind of dependency and the kind of lack of justice infrastructure across the globe. Even if you look at the MSMEs, we had over 6.5 million MSMEs, 65 million MSMEs in India, and less than 1% MSMEs comes to the court for the dispute resolution. It all shows that we do not have any access to the justice. Even if we have the access to the justice, but those systems are not being trusted by our citizens and the businesses, which I could also see from the past discussion and the past sessions, that a lot of judicial independence and many stuff has started coming up. So the most the biggest challenge across the globe is the access to justice. That's the first problem that my company is going to resolve it. The next problem is, next slide, please. See, our social structure is also changing. There is a deep integration between the cyber society or the cyberspace and the physical space. And 2/3 of the global population basically is now living in a newly created society called cyber society. So are we ready for the new society which is totally online, which are living their life? The internet has changed their way of life, they have changed their way of communication, they have changed everything. But our judicial system has not changed, and so we should work for our newly created society, which is called a cyber society. So our current judicial system across the globe is not ready to take this challenge. So this is the second problem that my company is addressing it. And third, next slide, please. And the most important thing which you would be agree, after the pandemic, of course, various courts across the globe have started using various kind of online tools, like, say, the online video conferencing and filing system and etc. But these are, I always feel these are just a small facilities. These are just a filing tools, having a conference or having a kind of the filing tools, etc., or maybe the Zoom, or these are rather creating more, posing more challenges, because these systems are silo systems. and all the data are basically is being stored in a different individual applications, and those applications which our judiciary or our other dispute resolution institutions are using, they are basically putting their data into insecurities, because all those data are lying not in their possessions, they are stored in a different kind of a server, and those data are asymmetrical as well. So what we have done, that we need a technology which basically work on a enterprise architecture approach. Our technology architecture should be on an enterprise based, so that the entire services can be delivered in an integrated manner on end-to-end basis. So one, the access; second, the newly created society; and third, the technology that we are currently using. These basically need a complete transformation. So I look technology not just as a part of digitizing your conventional practices and the processes. I look at the technology as a vehicle from transformation. I look a technology which basically envision an infrastructure which is natively digital. We should basically transform those processes which are basically is for a digital environment. We should not put technology into the processes, rather we should put the process into the technology. So technology should become a driving force. So this is what we basically advise on this part. And over to next slide, please. So Jupiter's vision, and see, the basic problem now we should look at is always look at the access. But we are forgetting one thing. Now justice is no more a sovereign function. It is not just a government function that they should come forward and deliver the justice. Justice should be thought of going beyond the sovereign function and should evolve as a service like other service actor does in the society. Like you go to Amazon, you buy things online. So same is the services. We should look justice not as a place or a courtroom where you go and get it resolved. It should be a services that basically should be defined as. So keeping this in this perspective, rather our judiciary, our government should think in a way that they should go to the litigant place rather than litigant should come to the court. Because when it is a service means that the customer should be happy. Like in India, we always say the customer is the king. So the justice should be delivered by the government, by the judiciary to the doorsteps of every litigant rather than they should come to their places. This is what the Jupiter's vision, and the whole technology which took us 4 years and almost about $10 million that we have spent is our driving force. Next, please. To achieve this, we already explained to you that we are not taking justice as a sovereign function. We are considering justice as a service. And this is basically is the driving principle. Next slide, please. So people generally confuse the justice means just like a courtroom that you have an access to go there. But I always say justice doesn't mean just like to approach an institution. Justice has 5 A's. One is, of course, the accessibility. You should basically have some kind of a courtroom where you can go there. So 5A access is called the accessibility, and second is the affordability. If your court fees is expensive, or the lawyer which are representing the clients are expensive, that means I would say that there is no access to justice. Even there are large number of the courtrooms, that doesn't matter. So the affordability is also very important when you define the access to justice. And third is the availability. Because most of the disputes as of now are being articulated to the legal mechanism, and for the purpose of understanding the law, for the purpose of understanding your rights, your remedies, you always need a legal services. So until unless there is no supply of the legal services or the lawyers, so there is no point, because even if you have the courtroom but you do not have the lawyers, there is no point, because you won't be able to have an access to the justice. And fourth is the awareness. And you see, the most important thing is the awareness. If you are not aware of your legal rights, you are not aware of your legal remedies, that means you are dumb. You have no idea whether you can get justice or not, whether this is a justiciable problem or not. That's very, very important in order to define the access to justice. And the last is the ability. The ability is just like, say, for example, you have been given an airport, government made an airport, so they basically there should be a means there should be a roads or the metro where you can reach there. Similarly, there has to be an ability. When I'm talking about the access to the technology, there has to be a digital infrastructure, there has to be a digital literacy to access those kind of information. So these are the 5 ways when we are defining the access to the justice. Next slide, please. So digital justice system, what Jupitis has done, we basically never wanted to work on a specific country or a specific dispute resolution process. We really, worked on an idea of Lego blocks. In a childhood time, we are basically building a lot of things by using the Lego blocks. So in 4 years, Jupitis has designed and developed a foundational digital infrastructure, which basically is a shared underlying technological framework which has various context-independent components, and they act like a Lego blocks. So now you are in Indonesia, you wanted to implement the dispute resolution system according to the Indonesian law. So our foundational digital infrastructure is so robust, it acts like a Lego blocks. You can pick up your blocks, you can assemble them and implement the system there. So this is what the hallmark or what you call the USP of the Jupitis justice system. Next slide, please. So these are the 9 components that these foundational digital infrastructures is consisted of. One is the platform, second is the processes, third is the connection. Because the system should not be only confined to yourself. The system should be that it can interact with the other platform. Because the government is not only doing one justice services, they are also rendering various kind of other public services. So all the systems should be connected through the APIs, they should interact with each other, they should share their data with each other. So our platform basically has an open APIs which can be integrated to any kind of other mechanism which basically is providing the public services. And then we have the data. We basically say data is the new currency, because data is something which we were talking about the judicial independence. Data is something which not only increasing the efficiency, which also provide you the ability to monitor and map the judicial, what you call the productiveness, their competencies, their efficiencies. You can evolve many kind of an efficiency metrics. And this is the data which gives you the end-to-end visibility. You can, because every kind of a smaller, tiny actions are logged into the computer and one can see, it creates a huge audit trail and one can see whether there was the judge was the bias or not, where there was independence or not independence. So technology play a very, very important role. So we always say a data, the skills. So Jupitis has also created a marketplace for lawyers, the arbitrator, mediator, and conciliators across the globe. We have just started last year from India. We have aggregated almost about 10,000 lawyers, arbitrators, and mediators. So it is just like, works like an Amazon platform where any disputant who wanted to get their dispute resolved can come on this platform, and based on certain parameter which help them to take informed decisions, they can find those kind of a lawyers, arbitrator, which not only give the ability and the supply, but also give them the very affordable and competitive price, because all the data and everything would be displayed on their profile. So next is the knowledge. And so Jupyter's basically is the strategy. We always say this is the architectural, enterprise architectural. This is what you call the proprietary architecture that Jupyter has developed. This is called Jupyter's EA, Jupyter's Enterprise Architecture. And this architecture was designed by adopting the world best methodology called TOGAF. So that is one of the best USP of any technology when you work on integrated in an integrated manner rather than to work in a silos where the information you are just losing it. Next, please. So this is the Jupyter stack. This is the way the Jupyter's platforms or the foundational infrastructure look like. So below you can see the circle is the data storage, and then it comes on the foundational digital infrastructure. So on this foundational digital infrastructure, now you can create, it acts like a Lego blocks, you can create various solutions, and you can use in your platform, use your dispute resolution mechanism. And top of it, you can also provide these services. Like say, for example, Jupyter has also created various kind of, we can't say that we are a code, we say that we have created a benches for the small business owner and the citizens, where we provide the professional arbitrator, mediator, and conciliators. And everybody knows that the decisions of the arbitration as per the United Nations Convention is just like a deemed court decree which can be enforced in the court of law. So we also created a small benches for the small claims and citizen and small business owners. They can come forward instead of going to the court, spending a lot of money. And while sitting at home, they can basically handle these, the kind of disputes. Next slide, please. So this is the focus area. So these are the focus area which basically Jupyter is focused on. One is the traditional digital transformation of the traditional judicial system, digital transformation of the quasi-judicial, which sometimes we say the administrative justice system, and the ADR mechanism, ODR mechanism as per the United Nations. This is one of the master kind of a platform that we have created under the United Nations procedural rule of the for e-commerce, particularly for e-commerce disputes, and the capacity building for ADR mechanism. So we have also introduced the Jupyter's Academy, where we are providing the training to the lawyers or the other experts to act as mediators, arbitrators, and so that they can also enroll them with us and provide services to the litigants across the globe. Next slide, please. So these are the solutions that the Jupyter offers. One is the digital court for judiciary and tribunals. Government as a platform, which this is basically is a recommendation by the United Nations, the recent survey of 2022, where they are assessing the e-government development index, where they say that we need an integrated system where the government can act as a platform, act like a single enterprise to provide end-to-end services to the citizen. And then digital ADR platform, we are providing this platform to all the ADR centers who wanted to work there, provide their arbitration, mediation services. We are giving them a complete total solutions so that they can make their clients to resolve their disputes from home. Then ODR platform, ODR marketplace, and DIALAW. DIALAW is it's a subscription kind of a stuff where we with the citizen or the small business owners, we started in India, but gradually we will be expanding to the other part of the world. It's anybody who wanted to know about their legal rights, about their remedies or some problems. In less than 60 seconds, they can get connected to the lawyers, which would be working 24/7, and they can have just a very small amount, maybe you can say about $15 or $20 a year, where they can, at any point of time, they can call for 10 minutes to the live lawyers and number of times. So we are empowering people to know their legal rights, to have their justice problem resolved by exercising their rights, etc. Next, please. So this is the illustration. Next slide, please. This is a complete kind of a process. We have not only provided the kind of a notices and the filing, the entire process you can see right from filing to decisions. Every task which almost about 300 type of different tasks can be performed on the platform. You need not to jump on and off the platform. Next slide, please. And this is the same as the back office, which is the registry office, where you can allocate the case, you can issue the notice, you need not to enter the data, and you can do every back office operation from the platform itself. And this is the special consideration, whole of the system. We do not only resolve the disputes, we have the system where you can mitigate and contain the disputes. This is for the digital literacy people, language locations, and inclusive and accessible system. Next, please. And these are the few cases that we created. We created the various kind of code. You can look at the screen. We have created the various codes for the Indian government as well as the judicial systems. Next slide.
Mr.
Please.
Rahman, you have 2
Yeah.
minutes behind?
Yeah, just last.
2 minutes left, sorry.
Yeah, last.
Yeah,
Just
thank you.
last. I'm showing
Thank
the
you.
outcome, so let's make it fast.
Thank you.
So you can see now, this is what I was just talking. So I am just giving you a slide. You can look at it. You can Google it. Our platform in India has made a historical thing. They resolved over 13 million cases in a day. So this is the kind of cases means 13 million cases, and every case has 2 people. That means 26 people were managed in a single day. Almost 1 European country's cases in a single day were handled on this platform, which is a very popular court called Lok Adalat, which is called a people court. And this is the outcome of this platform, which has been appreciated by our Chief Justice of India. Next slide, please. So this was launched by our Chief Justice. Next slide, please. So this is a way forward. Now we have invested huge into the artificial intelligence, blockchain, AR, VR, where now instead of having a traditional type of digital conferencing, your hologram would also be transported and sitting like in your conference room as if lifetime kind of a conferencing. We have heavily invested into AR, VR. Very soon, we will be coming out a different kind of a video conferencing. Next. Thank you. Thank you very much. Any questions here?
Thank you so much, Mr. Rahman Agarwal. This is amazing, very insightful. How to embrace the technology and then to embed it in the justice technology. So, Mr. Rahman, we would like to ask for your keenness to kindly return to your seat because we are running out of time. Is there any one question from the floor, perhaps? We still have half minutes. One question, madam. Please kindly help to give the microphone.
Super fascinating. Thank you so much.
Thank you.
I read with real interest the ODR policy framework that India adopted or published earlier this year. Is that something that will benefit this platform? Because as I understand, they want to have ODR as part of their formal justice mechanisms.
Yes.
Can you just give me a little bit of a...
So ODR, we have done a great research on the ODR. So ODR I'm taking as a mechanism which has been conceived and adopted by the United Nations in the General Assembly in 2016. So United Nations had basically created and adopted a technical notes on the ODR. And that's, of course, is a very, very good mechanism, which I always say a fourth mechanism, because this small claim and large volume dispute, especially in a e-commerce environment and cross-border environments, there you cannot get it sorted out. It is the ODR mechanism, which is a 3 stages process, which you can start with the negotiation or the mediation, and ultimately, depending on the national law or the judicial law, you can go to the last step that called the arbitration. And everybody knows that in the United Nations Convention on the recognition and enforcement of the award, almost 166 countries, any award which is passed by the arbitration is enforceable depending on the national law in almost 166 countries. So we have made a very fantastic, so user-friendly, and even you don't need any kind of a lawyer, and that ODR platform we have created, and anybody, anywhere, who are doing small transaction, large transaction, e-commerce, or otherwise also, this platform would definitely help. And even the ministry in India, the Consumer Affairs Ministry, and they have now appointed us to create that ODR for the consumer, to create a national helpline integrated with the ODR without going to the Instead of going to the court, they should come and settle through the ODR mechanism. So Niti Yog, our planning commission, has introduced the policies in 2021.
All right, the greatest applause. Mr. Raman Agrawal, we would like to ask
you
your
very much.
keenness to
Thank you,
kindly
guys.
return to your seat. Thank you so much. Distinguished guests, ladies and gentlemen, we're going to proceed to the next second interactive sessions on access to justice for minorities. We have two parts under the sessions. The first one will be best practices and innovation presentations, and the second part of the interactive sessions will be interactive discussions. Both of these two parts of the session will be led by our moderator, Hannah Lim, as the head of Rule of Law and Emerging Markets, representing LexisNexis Southeast Asia. I would like to invite Hannah Lim. Please kindly lead the session and give the greatest applause, ladies and gentlemen.
Testing. All right. Hi, everyone. Thank you for the World Justice Project for having this session. So this morning we looked extensively at the Rule of Law Index data, and then after that we heard about the strengthening of judicial independence. And judicial independence, of course, is extremely important, as the judiciary is, these are the institutions that are responsible for upholding justice for our communities. Now, for this section of this program, we are going to be looking at access to justice, particularly by minority groups. I think Justice Shirani in the earlier session talked very inspiringly about the role of judges in extending the hand of power to people who may be less fortunate, may not have that power, and ensuring that justice is served. So I think in this session, we'll be exploring that concept a little bit more deeply, specifically how we can help to extend that hand of power to minority groups. And with respect to minority groups, these are sections of our population whose experience of justice institutions may differ from the mainstream. Their experience may not be as accurately reflected in data and studies as the median. So we would like to explore from our experts today how their work addresses these concerns. So in terms of format, the next 1.5 hours, I believe I still have 1.5 hours. Okay, will be divided into a couple of sections. So the first will be introduced to 3 projects, when we will learn a little bit more about 3 specific projects and how they have positively impacted the communities that they work with. After these presentations on these 3 specific projects, we'll move over to an interactive panel discussion where we'll be hearing from more experts. So in terms of the objective of this section, we are looking to achieve 2 things. First is to understand what is the scope and scale of challenges relating to access to justice for minorities in the Asia Pacific. And the second objective is how can we tackle these challenges together? Okay, so in interest of time, I won't be introducing each and every speaker and presenter. At the back of your program, there is a QR code, so you can scan that to learn a little bit more about the presenters. And so without further ado, I would like to introduce our first speaker, Veronica Rios. She is my colleague from LexisNexis, and she'll be sharing on a couple of projects. Thank you.
Thank you, Hannah, and good afternoon, everybody, and thank you to the World Justice Project for pulling us together for the next few days. It's been a very insightful session so far. So for those of you who may not be aware of LexisNexis or may not have heard of LexisNexis, I'll just quickly touch on who we are. We're a global provider of legal research content and technology solutions. So we produce content for lawyers. We publish legislation, case law, legal textbooks, and subscription works, and we make this available in hard copy format and online. We cover 175 countries across the world and employ over 10,000 people globally. But, you know, it might sound like we are a typical global corporation, but what I think, and I'm sure Hannah would agree with me, what does set us apart is that we have a very genuine, a very real dedication to our global mission, which is to advance the rule of law. I've actually got some slides, if we could get those up, that'd be great. So our global mission at LexisNexis is to advance the rule of law, and we do this obviously through our everyday work when we provide legal content to lawyers to help them administer justice. But what we do is we actually take it a step further. We know that within our business, we have resources and capabilities that we can put to good use. And so what we do is we seek out partners and projects to work on to advance the rule of law. The reason why we're so dedicated to advancing the rule of law is because we do believe that the rule of law is good for everybody, but also it is good for business. A couple of years ago, we've obviously followed the Rule of Law Index for a number of years. We always read the reports and we're always very keen to see what has been reported on that year. A couple of years ago, we decided we would take that data and we would layer over it some data from the World Bank and from Transparency International. Next slide, please. What you can see here, sorry, from that first image, we found that there was a direct correlation between countries that had a strong rule of law index. You can see here sort of that picture there on the right. Countries that had a strong rule of law index also had a high GDP per capita. We then thought to ourselves, well, with this correlation, what would happen if we were to increase the rule of law mean score by about 10%, a slight shift? What impact would that have economically or on social factors? And so using the data that we layered over and brought together, we theorised that by increasing the rule of law by 10%, we would see an increase of GDP of about $7,000 per person. We would see a decline in homicide, so that's that 1.1 per 100K. We would see child mortality decrease, and the average life expectancy in adults increased by about 2 years. Now, the image that you're looking at here was developed by analysts within LexisNexis. So we had the analysts work with the data, and we had our data visualization team actually create this tracker. Now, this is an interactive tool. So if you Google Rule of Law Impact Tracker, you'll be able to slide that dial across and see the impact of increasing the rule of law. But this now brings me to, the topic of today's session, which is sort of best practices and recommendations when it comes to partnering for the rule of law. So we said to our teams, okay, we want to do this study. Who wants to be involved? And our data analytics team and our analysts all put their hands up because they were keen and they had the skills. Now, some of our core skills at LexisNexis is obviously working with legal content. We consolidate legislation daily across a number of jurisdictions. And so through our various conversations with different governments, when we found out that there were a number of governments that had never consolidated their legislation before or hadn't consolidated their legislation in a very long time, we knew that there was an opportunity for us to deploy our resources and our skills to help. Next slide, please. So back in 2016, we kicked off a project with the Attorney General's office in the Maldives. The Maldives had never consolidated their legislation before. We sent in our team. It was very much them on the ground, trawling through filing cabinets of paper, pulling together different principal legislations and matching it up with different amendments. And after quite a lot of work, we published the first consolidated set of the laws of the Maldives, which is that green set of binders up the top there in that image. But we understand that accessibility is also key. So we worked with members of the profession within the Maldives to translate these laws and publish them on a LexisNexis website that you can see there. We've now also consolidated the laws across a number of Pacific islands, including Fiji, the Cook Islands and Nauru. Now these projects again was us deploying our very skilled people, sending them to these countries, having them spend quite a lot of time working with their stakeholders and their partners to really make these projects work. The other piece is, though, that we obviously rely on their skill, but what sets us apart is that our people are very passionate about the work that we do. My colleague Hannah is from our Southeast Asian business, and when they heard that the High Court of, was it Kota Kinabalu? Yeah. they had decided to launch this initiative called the Mobile Courts. The mobile courts were going to set out into the rural areas of Malaysia to service the members of those communities who had limited to no access to legal services, including birth and marriage registration. Now, without birth registration services, you were deemed stateless. And so when we heard about the mobile courts, next slide, please. Oh, sorry, this is the Cook Islands and Nauru. Next slide. So when the team and Hannah heard about the mobile courts, they jumped at the opportunity to join the expedition. Now, this was over a few days, like hours of driving through rocky terrain, camping, you can see the tents there, camping with members of the mobile courts, and LexisNexis's role was to support the members of the mobile court, but also to help to educate the people in these villages about the importance of these types of registration services. Now, I think we've been part of that expedition now since 2018, and it's certainly something that we opened the opportunity up to all of our staff. So we had staff who were from a marketing function, from our product and technology functions, from editorial, going along to this mobile court. So the first recommendation I think that I've been trying to describe here is that we leverage our people, we leverage their skills, and we leverage their passion. But the other thing that we also have at our, a vast resource of is technology. So as a legal content provider, we provide our content through different means of technology. Next slide, please. So a couple of years ago, there was a broadcaster in the UK, and they broadcast a documentary on the killing fields in Sri Lanka. And as part of that documentary, they aired a short clip that was taken on a mobile phone of one of the Sri Lankan soldiers, which looked to show the execution of a Tamil soldier. Now, the government had claimed that that video was fake. But then eventually, I think a few years later, the United Nations actually verified that the video footage was real. However, the video footage didn't have the requirements that met sort of evidentiary standards, and so therefore it wasn't admissible in the court of law. So we, LexisNexis, have had a long-standing relationship with the International Bar Association, who also are very keen and dedicated to advancing the rule of law. Next slide, please. So the International Bar Association went on to create an application called Eyewitness to Atrocities. The Eyewitness to Atrocities app allows you to capture war crimes or footage of crimes. If you are a passerby, you can download it onto your phone. But what they set out to do was securely save those images and the videos on servers with the required data needed for to be admitted in court. So that includes, details around pixelation to make sure that the images and the videos have not been tampered with, timestamps, date stamps, and all of those requirements. And the role that LexisNexis plays in this is that we offered up our servers. So we obviously have a number of servers around the world, so we were more than willing to get involved in the development of such an important application, and to this day we continue to do so. The Eyewitness to Atrocities app has been used to capture over thousands of hours of video footage, unfortunately, and some of that evidence has been presented in the International Criminal Court. So this is an example of us, again, leveraging what we have, our resources and our technology, in order to play a supporting role. We may not be leading the initiative, but we look to understand what we can contribute and what we can provide. Next slide, please. This is a more recent example of us utilising our technology. So when we heard about the war in Ukraine, we felt that there was something that we should do. So what we did was we connected with the Bar Association, the Law Society of Ukraine, and we created what we call the Legal Aid Portal. And on this portal, what we've done is we've invited our clients, our contacts, our networks, to post on this portal any pro bono opportunities that they would like to offer, any job opportunities that they maybe have going in their respective networks. And then we link them up with members of the Ukraine Law Association. So it's sort of like a portal where they're able to connect and pick up on opportunities. And this is available for Ukrainian lawyers and their families as well. So this platform was built by our technology team. Okay, next slide, please. So finally, this is the last slide. What you see here is a copy of our internal rule of law project board. And so not all of our rule of law projects are big, huge application developments. Some of them are research papers and sort of smaller projects, but we publish these up on our internal intranet and we invite our staff to get involved. So in terms, just to summarise and finish off, the recommendations or the best practices that we at LexisNexis tend to abide by is that we leverage our core skills, we leverage our expertise, our research, the passion of our people, and we get them on the ground, we get them involved at a grassroots level. I'm going to hand back to Hannah now, but thank you very much for your time.
All right, thank you very much, Veronica. And I'd now like to invite Ms. Doreen, from an Access to Justice specialist from UN Women from Bangkok.
Thank you so much. I'm not going up the stairs. I'm quite clumsy. I might fall, so I just stay here. Great. Thank you so much for having me. It's been really fantastic. A lot of interesting discussion and presentation. So my name is Doreen Büttner. I'm working as a justice specialist with the United Entity for Gender Equality and the Empowerment of Women, based in Bangkok, where we have our Asia Pacific regional office. Great, I have the slides up. That's fantastic. So nearly here in the region, we have nearly 700 million people with disabilities. Over half of them are women, and a lot of them are having an intellectual or psychosocial disability. I have worked with access to justice, rule of law for around about 15 years now on all continents pretty much, and I'm yet to see a justice mechanism that consistently serves women with intellectual and disability and provides justice for them. I'm getting my notes confused, so bear with me. But I have the graveyard shift here, so everybody seems to be tired, so it's me too. So what I would like to talk about today is a people-centered approach to access to justice for women with intellectual and psychosocial disability. And before I start, just as a little side note, we always group intellectual and psychosocial disability together, and I think that's great for advocacy processes. But if we really want to talk about justice, I think at a certain point we have to divide those two groups because they are quite different legal approaches. But that is just what I think, and today it's not about what I think, but it is about women with intellectual and psychosocial disability, so we should listen to them. And that is exactly what we did over the last 6-7 months. We listened to women with intellectual and psychosocial disabilities. We established a growing partnership with disability organization, self-advocates, and we listened. We let them tell us what kind of legal needs they have and what problems do they face. And just to name a few, of course, in most of the countries, or in many countries, women with intellectual disabilities don't have legal capacity. So that is to begin with. They have their credibility questioned whenever they have a legal problem. Information is not in a format that they actually understand. And there is, of course, also a lack of support throughout the justice chain. The justice providers don't have the skills or the tools to support. And often it's quite basic, just like they don't have the financial means to actually engage with the justice system. Can I have the next slide, please? As with many other justice issues, a glaring problem that we encountered while we started the work is there is no data. We don't know the legal needs of women with intellectual and psychosocial disabilities in Asia and the Pacific. And this is where we started. We engaged a leading research team from the University of Galway to co-produce a legal needs survey for women with intellectual and psychosocial disabilities. We have 4 pilot countries, that is Fiji, Nepal, Indonesia, and the Philippines. We were really keen to learn about the challenges that women face from the women, so we can find solutions together that are actually evidence-based. So the process that we used was rather unique, and I really encourage other organizations, other countries to pick up on this kind of surveys and legal needs surveys for women with intellectual disabilities, because we really want to capture the voice throughout the Asia-Pacific region. Can I have the next slide? So how did we go about it? First of all, we established a stakeholder group of partners and organizations led by people with disabilities and their supporters. And they worked with the research teams in the countries to adapt the OECD legal needs survey to meet the needs of women with intellectual disabilities. And what was important to us is that throughout the survey, throughout the development of the survey, that we have women with intellectual and psychosocial disability actually involved and actively engaged. So how did they do that? For example, they advised the research team on the adaptation of the survey to ensure that the questions were relevant, that they were culturally and contextually fitting, and of course that they are understandable. They participated in discussion and the drafting process and provided inputs based on their lived reality. They also helped us to establish like an easy read and the imagery that should be used so that actually people understand what we want from them. And they provided in-person support when it was needed. For example, a support person, they made sure that there is ample time for little breaks, they made sure that there is enough time for explanations and so on. Nonetheless, we were of course not able to reach all the women that we would have loved to reach. They were challenging, of course, in reaching remote areas. Also, we had difficulties reaching women where there are no strong disability networks or organizations. And especially the most vulnerable who live in isolation, may it be at home or institutions, are really, really hard to reach. And we definitely have to find a solution to reach those women as well. So the result of the legal needs survey, we are in the middle of it. We're analyzing, not we, our partner organization analyzed the data, and we were happy to share that next year. What we discovered, or a little sneak peek, it's not a big revelation, some of the main legal problems identified by the participating women were issues in domestic relationships, workplace violence, denial of reasonable accommodation, problems opening a bank account and control over their financial affairs, denial of health care, and problem accessing education. So there were a couple of those. I don't really want to kind of provide a preset of premature recommendation. I think we are not there yet. I haven't seen the perfect model yet, and there are still a lot of discussions that we have to have before we can do that. But I think I would like to ask a couple of questions, because we all work on justice, and I think just to have those questions in mind when you do your work might be helpful. First of all, is the formal justice system fit for purpose when it comes to persons with intellectual and psychosocial disabilities? I see the response. And if not, can we fix it? Or is it better to find, or to diversify, or find other solutions that actually support the justice journey for women with intellectual and psychosocial disabilities? That is one of the questions. And then the other one that is really close to my heart, how can we do better with prevention? A lot of legal issues can be prevented. And that includes ensuring that barriers of participation, full meaningful participation of people or persons with disabilities are considered. And then knowing, we've heard about the massive justice gap globally. Closing the justice gap and financing justice is a massive undertaking and needs a lot of thinking and creation and innovation. But how do we ensure that with that we don't largen but narrow the justice gap also for persons with intellectual and psychosocial disabilities? And that is when we talk about decentralization, when we talk digitalization, when we talk standardization. We really have to take to heart that there are some people that might find it difficult to access or are forgotten when the discussions are led. So I encourage you to kind of keep that in mind.
Miss Doreen, I would like to remind you have 1 minute left.
That's fine,
Thank
because
you.
it shouldn't really end with my voice, but we have if you can go to the last slide.
Thank you, madam.
I want to share with you a short clip from one of our advocates, Petra Angelina. She is Indonesian and she participated in our legal needs survey. Actually, when we had the justice speaking earlier, it was Petra Angelina who interrupted her with that video clip. It somehow went off, so I don't know. But please listen to her, be inspired by her, and if justice for women with intellectual disability and psychosocial disability is as close to your heart as it is to ours, please reach out and we see how we can work together. So over to Petra. One more click and we should hear her.
Have you ever wondered what it would be like to go to police station and not be able to get justice because you are not considered credible? Can you imagine how you can live in society without a bank account because you can open one with a legal capacity? How about receiving an unwanted letter from a court or lawyer but not understanding it? How would you feel knowing people might see you as an easy target for violence and crime? Because perpetrators are hardly ever punished. This is especially frightening as a woman. The justice system needs to change. It needs to work for everyone.
Terima kasih.
Thank you very much, Doreen. Sorry, could I have the microphone back, please? Thank you. All right. Next, I'd like to invite our next speakers, please. And given our time constraints, I'd like to ask you to keep it to 5 minutes if possible. And they are Pak Muhammad Hadia and Andi Tatkia from Sulawesi, who will be speaking about their project. Terima kasih, Pak. Terima kasih, Pak.
Ladies and gentlemen, we would like to inform you that Pak Muhammad Haidir, as the Director of Makassar Legal Aid from LBH Makassar, and also Pak Andi Takdir, Paralegal and Head of People with Disabilities Indonesia Association or PPDI from Bone District, South Sulawesi, will speak in Bahasa Indonesia. So we would like to ask for your keenness to use the SIS receiver and please kindly select channel 8 for English interpretation. Thank you very much. Bapak silakan.
Cek. Ya, bismillahirrahmanirrahim. Assalamualaikum warahmatullahi wabarakatuh. Selamat siang. Perkenalkan, nama saya Andi Takdir. Saya Ketua Disabilitas di Kabupaten Bone, Sulawesi Selatan. Saya juga salah satu korban penganiayaan secara bersama-sama oleh Oknum Satpol PP di Kabupaten Bone di tahun 2017 lalu. Videonya masih tersebar itu di YouTube waktu itu. Waktu 2017 lalu itu, akhir 2017, saya mengalami penganiayaan itu di bulan Desember. dan saya sempat melaporkan ke pihak kepolisian tentang penganiayaan tersebut, dan sampai 1 minggu tidak ada kabar perkembangannya, sehingga saya berinisiatif untuk pergi ke Kota Makassar meminta perlindungan hukum kepada teman-teman LBH Makassar waktu itu, dan akhirnya teman-teman LBH Makassar mendampingi saya sampai kasus tersebut terselesaikan dan sempat divonis 2 bulan 20 hari waktu itu. Jadi sedikit saya ceritakan kronologisnya waktu itu. Pada bulan Desember 2017 saya dan anak saya yang masih berumur 4 tahun saya datang ke lapangan Merdeka menonton breakdance, latihan breakdance. Kemudian segerombolan Satpol PP datang menghampiri saya dan berdebat dengan saya karena mereka mau membubarkan acara tersebut, dan saya mau melindungi teman-teman yang breakdance ini. Kemudian saya dihampiri, kemudian saya dipukuli secara bersama-sama waktu itu. Ada sekitar lebih 10 orang yang menganiaya saya, cuman hanya 3 orang yang terkena yang tersorot kamera. Akhirnya hanya 3 orang yang ditangkap pada waktu itu. Kemudian setelah divonis 2 bulan 20 hari, berbagai macam rintangan saya alami waktu itu, mulai dari intimidasi dari pihak pemerintah dan juga preman-preman yang ada di kabupaten saya. Sampai-sampai rumah saya dilempari batu dan pecah jendela saya di tengah malam waktu itu. Namun saya tetap terus lanjutkan sampai kasus ini selesai. Setelah kasus ini selesai, saya diundang oleh teman-teman LBH Makassar di 2018. Saya diundang untuk ikut pelatihan paralegal inklusif di tahun 2018 tersebut. Dan kemudian setelah itu, setelah ikuti pelatihan, saya ikut juga mendampingi teman-teman disabilitas yang mengalami berbagai ada yang pelecehan seksual yang dialami teman disabilitas berat di Kabupaten Bone. Dan waktu itu juga waktu saya dampingi teman tersebut sempat dihukum 7 tahun 7,5 tahun pada waktu itu, karena pelakunya waktu itu adalah orang awam juga pelakunya. Setelah itu ada lagi saya dampingi teman disabilitas tunarungu di bawah umur, dan pelakunya lagi-lagi pelakunya adalah Satpol PP. Namun kasus ini berhenti karena banyak orang-orang di atas, orang-orang pejabat-pejabat yang melindungi Satpol PP tersebut, sehingga kasus ini berhenti karena diberi orang tua korban diberi uang 40 juta dan dinyatakan selesai karena orang tuanya sudah tidak keberatan dengan kasus pelecehan tersebut. Dan kami sempat menyampaikan ke pihak kepolisian, namun pihak kepolisian tidak menanggapi kami karena mereka menganggap kasus ini sudah tidak ada yang keberatan dengan kasus tersebut. Dan jadi itu yang saya dampingi di Kabupaten. Kemudian ada juga yang saya dampingi ODGJ melakukan pembunuhan anak di bawah umur, dan kami dampingi sampai kami bermohon ke pihak kepolisian untuk melakukan pembantaran untuk teman disabilitas ODGJ ini. Sampai sekarang ODGJ ini dibantarkan di Rumah Sakit Dadi di Kota Makassar. Jadi itulah cerita singkat saya dalam menangani kasus awal mula dari korban kekerasan tersendiri. Terima kasih. Assalamualaikum warahmatullahi wabarakatuh.
Ya, saya lanjutkan. Mungkin slide-nya bisa dilanjutkan. Nah, ini tadi Pak Takdir cerita soal bagaimana pengalaman dia mendampingi. Data ini adalah salah satu kasus mungkin juga pernah ditangani oleh Pak Takdir. Data ini selama jadi di 2 kabupaten kota, Bone dan Bulukumba, kami bekerja sama dengan IPJ 2 untuk salah satunya adalah melatih paralegal, melakukan pemberdayaan paralegal. Dan kemudian data ini adalah data yang ditangani oleh paralegal. Data ini adalah data penanganan kasus paralegal bersama advokat inklusi di 2 kabupaten kota, Kabupaten Bone dan Bulukumba, yang menangani kasus masyarakat rentan berhadapan dengan hukum, anak, perempuan, dan disabilitas. Lanjut. Nah, khusus untuk disabilitas ini datanya. dan juga jenis-jenis disabilitas, gitu. Juga jenis kelamin dan usianya. Lanjut. Nah, dalam penanganan kasusnya kami menemukan berbagai macam kendala. Salah satunya tadi sebenarnya sudah diceritakan oleh Pak Takdir, bagaimana kendala misalnya harus didamaikan, sampai kepala desa pun harus ikut mendamaikan dan lain-lain, yang sebenarnya kasus itu tidak mendamaikan dengan tidak melibatkan korban. Gitu. Sama sekali melibatkan mungkin hanya orang tua yang dilibatkan, gitu. Tanpa melibatkan korban. Nah, kemudian dari banyak kendala, termasuk misalnya bagaimana asesmen profilnya yang harus dijamin, kemudian penerjemah, juga akomodasi yang layak lainnya itu. Nah, kemudian kami mendorong satu peraturan bupati di dua kabupaten kota ini, yang kemarin di tahun ini baru saja disahkan. Peraturan bupati ini kemudian, ini adalah model peraturan bupati gitu. Model peraturan bupati yang kami dorong. Sebenarnya ini adalah model ideal yang kami dorong, di mana layanan yang tidak disiapkan oleh kepolisian, layanan penerjemah kan tidak disiapkan oleh kepolisian, kemudian asesmen profil itu sama sekali tidak disiapkan oleh kepolisian, sampai ke pengadilan malah. Layanan khusus lainnya itu tidak disiapkan, termasuk rehabilitasi, reintegrasi itu tidak disiapkan oleh layanan peradilan. Nah, kemudian kami melihat bahwa sebenarnya layanan ini itu ada di Pemda, bisa disiapkan oleh pemerintah daerah, di pemerintah kabupaten. Makanya kami mendorong ada layanan itu disiapkan khusus untuk disabilitas yang berhadapan dengan hukum. Ada layanan rehabilitasi dan integrasi, kemudian layanan penerjemah, ada pendamping disabilitas, juga kemudian tentu saja layanan hukum, layanan bantuan hukum. Itu juga disiapkan gitu oleh Pemda, dan itu layanan seharusnya terintegrasi melalui UPT, itu dorongan idealnya. Itu. Tapi ini tidak, karena ada banyak hal-hal teknis peraturan pembentukan perundang-undangan yang harus diikuti. Lanjut. Nah, ini yang ada di Perbub saat ini. Tadi itu kondisi ideal yang kami cita-citakan, dan ini adalah yang ada di peraturan bupati saat ini. Di peraturan bupati kenapa itu ideal tidak jadi, tadi ke soal teknis, misalnya dalam membentuk satu lembaga khusus itu harus banyak hal yang harus dilalui. Untuk mempersingkat waktu, sementara ada banyak kasus yang harus ditangani, maka kami mendorong peraturan bupati yang seperti ini. Tadinya misalnya penerjemah itu sama sekali tidak ada layanannya di Pemda gitu, tidak ada layanannya juga di kepolisian, maka kami dorong Pemda untuk mengambil tanggung jawab itu melalui peraturan bupati ini. Begitupun dengan bantuan hukum, gitu. Bantuan hukum dan lain-lain itu. Lembaga, nah misalnya ya ketika LBH membutuhkan penerjemah, dia bisa meminta itu ke Pemda. Meminta itu ke Pemda. Ketika misalnya kepolisian membutuhkan penerjemah, juga bisa meminta ke Pemda. Ketika dia sudah dihukum, dia membutuhkan reintegrasi, rehabilitasi, maka dia juga bisa meminta itu ke Pemda. Nah, yang sejauh ini kan tersebar dan tidak bisa diakses. Di satu sisi ada paralegal yang juga bekerja. Ada paralegal yang juga bekerja memberikan informasi tentang layanan-layanan ini. Harapan kami sebenarnya adalah ini bisa diadopsi, khususnya tadi yang diadopsi secara nasional, khususnya tadi yang ideal, bahwa ada satu unit pelaksana teknis sendiri yang kemudian memberikan layanan aksesibilitas kepada disabilitas yang berhadapan dengan hukum. Tentu saja tidak hanya bicara hukum, tapi juga misalnya layanan pendidikan, layanan kesehatan, itu bisa ada satu UPT-nya sendiri nantinya yang mendorong yang nantinya agar aksesibilitas itu bisa lebih mudah dan bisa menasional gitu. Kita bisa mencontoh UPT PPA, itu UPT PPA di semua daerah. Tadinya hanya ada di nasional dan kemudian itu bisa menyebar ke seluruh wilayah di Indonesia. Mungkin itu saya ucapkan terima kasih. Selamat sore.
Selamat sore, terima kasih Pak Muhammad Haidir dan Pak Andi Takdir. Ms. Hanalim. Bapak, kami minta kesediaannya untuk tetap di tempat. Ada beberapa mungkin pertanyaan yang akan diajukan oleh Ibu Hanalim. Kami akan bantu memberikan alat penerjemahan sehingga mempercepat waktu ya. Mohon ditunggu sebentar. Going to ask some questions. Do you have any Q&A?
Testing. Hi. Sorry, the microphone wasn't working. Thank you so much, Pak, for your sharing. And I think we heard very interesting insights today from our presenters on their projects. Now I would like to invite the rest of our panelists to please join me on stage. And they are Pak Dio, who's the co-founder and executive director of the Indonesia Judicial Research Society. So Pak Dio, would you please join me on stage? We also have AJ, who's the executive director of the Public Defender Society of Nepal. We have Fujita-san, who is going to be joining us virtually, and Ms. Ankana, UN expert and member of the UN Working Group on Enforced or Involuntary Disappearances in Thailand. Could you please join me on stage? Thank you very much. So we heard a lot from our presenters this morning, and I think a very key theme is really hearing and understanding the perspectives of minority groups themselves. So we're hoping to be able to flesh that out a little bit more in this next section. Just a note for our speakers, we are running short on time, so we would like to request that you keep your presentations to 10 minutes, and then we can have some time for question and answer. I also understand that Mr. Fujita-san would probably have to leave a little bit earlier, so perhaps, Fujita-san, if you are here with us, would you like to perhaps start? The first question could go to you, and that would be to first introduce yourself and your organization, and to perhaps share a little bit about the experience of LGBTQ people, particularly in Japan. I understand that your organization is the Lawyers for LGBTQ and Allies Network in Japan. Could you please share with us your experience, your perspectives, and perhaps also what perhaps are the main challenges of this community that you have supported? Thank you.
Do you hear me now?
Yes, we can. Please proceed.
Great, thank you. Thank you very much. And I'm very honored to be here to share the experience of the Japanese situation as it relates to LGBTQ plus community in Japan. So thank you. I did prepare a set of slides. I'm not sure if it is ready for showing.
Could we bring up Fujita-san's slides, please?
Thank you very much. So please skip this one. So by way of introduction, don't skip everything, please. So by way of introduction, my name is Naosuke Fujita, and I am a co-chair of a non-profit organization in Japan called Lawyers for LGBT and Allies Network. We are unique in the sense that we represent a business community. We are all business lawyers. We founded ourselves in 2016. Personally, it was when a colleague of mine came out at work in Japan. I used to work for a financial company in Japan, and it was very rare in Japan for a colleague to come out at work. And that was when my personal engagement started. And I felt that, first of all, there was very little awareness in Japan, and I did not realize the various pains and sufferings and the difficulties that the LGBTQ plus community was facing in Japan. And that's when my journey started. And we ended up reaching out to my colleagues, to other lawyers, business lawyers, and we founded this community. We now have about 200 members. We've organized over about 100 events, and we do it across Japan, primarily in Tokyo, the capital city of Japan, but we've tried to expand our events across the nation. If you could please turn to the next slide. Our mission is really to achieve equality for all. And my personal mission is I want Japan to become a society where my colleagues, my friends, my family could be their true selves and really provide with their best selves in community. And we felt that in Japan, there were two key pillars we had to focus on. The first was awareness. There is very little awareness in Japan. Things have started changing gradually in 2015, so that was about 7 years ago, but the pace of change is not where we would like it to be. And without awareness, we can't have a dialogue. And without dialogue, there won't be change. So we wanted to start a movement, particularly in the business sector, of awareness and dialogue that would lead to advocacy, meaning a change. And what do we mean by change? Could you turn to the next slide, please? So this is where Japan is. This chart comes from an OECD report that was published in 2020. That was a survey that the OECD did. It's called Over the Rainbow, and it ranks the 35 OECD countries listed here in terms of the rule of law, in terms of LGBT inclusive legislation that each of these countries have enacted. And unfortunately, as you will see, Japan ranks 34 out of 35 countries, OECD countries, just after Turkey. And that is because we have no really specific law addressing LGBT. We don't criminalize homosexual activities, but beyond that, we have no law, except in a very limited way, that prohibits discrimination, that prohibits hate crime, that adds sexual orientation or gender identity as a category. So how do we go about changing this? Next slide, please. So what is our strategy? And our strategy was, how do we reach the hearts and minds of the people? Because without dialogue, without understanding, without awareness, there will be no incentive, there will be no motivation to change the law. And we think it is very important to change the law. And what are the tools and how do we go about doing that? Next slide, please. So we first thought that we should find strategic partners to work with, because the society is segments of various people and support from every segment is required. We work with LGBT activists in Japan. Some of them are LGBTQ, some of them are allies. It is very important to change law. You need the support of the legislators, the politicians. So we reached out to politicians. And lastly, but in our own field, we reached out to the corporate community. This is all a work in progress, but if you could turn to the next slide. Here are some of the LGBT activists. They have been gaining momentum, particularly in the past several years. Some work in the corporate sectors. Some have used the Tokyo Olympics as a leverage to promote awareness. And some, as I will touch on later, have started a social movement that is tied to leveraging the judicial system. Next slide, please. We've worked with politicians. The ruling party in Japan is not yet supportive, but they are supportive of raising awareness, but not of introducing anti-discriminatory legislation or marriage equality. But there are certain legislators that have been generally supportive, and I've listed some of them that we've worked with to help promote awareness in the legislative sector. Next slide, please. We have found that the global allies have been particularly helpful. We reached out to them, and to our surprise, they helped us out. We did not know where to start. They shared with us the strategy for moving people's minds in Japan. On your left, you see Evan Wolfson. He's said to be the godfather of marriage equality in the United States. He worked on realizing marriage equality for 30 years in the United States. He gave us a lot of good idea. As lawyers, we were originally focused on using litigation. But he said that litigation itself will not move people's hearts and minds, and that we have to focus on the social movement. And he taught us how we could start a social movement. And then we have legislators from the United States, from Europe, and also we found out to our surprise that the American Bar Association and the Law Society in the UK, those who are also willing to provide help in the form of a formal written letter to Japanese authorities to help move the cause. Next slide, please. I wanted to focus on marriage equality because that has gained tremendous traction in Japan and is representative of the Japan's effort to move the social, to move the society. So if you could turn to the next slide, please. We first wanted to prepare the grounds for change. And in order to do that, we worked with the business sector. So if you could turn to the next slide. We called out to the business sector, more specifically the American Chamber of Commerce and the other chambers of commerce in Japan, to ask them to issue a statement of support that marriage equality is required in Japan, fundamentally because of human rights, but also because it is critical for Japan to have diversity and inclusion, to advance society, to be competitive, because without diversity, we will be a declining and lagging nation, lagging behind other countries. So what we did, please, next slide, please. We published what is called a viewpoint, asking for corporate support and for corporates to voice their support, not just be silent about it or not just limit it to their own company, but to actually voice their support. If you could turn to the next slide, please. This was launched in 2018. Will the slide move to the next one? Yes. So over the couple of years that we've been working on it, 132 companies and businesses have expressed support. Next slide, please. And this was, as you will see, first focused on the foreign community in Japan, but it has gradually expanded to the Japanese corporate sector. If you could turn to the next slide, please. We tied with a Japanese group of social movement drivers. And with that, we now have more than 300 companies, both non-Japanese and Japanese, doing business in Japan, supporting this cause. And the voice has been gradually growing. It's still a very small fraction, but we think that this has been very effective, and we'll say why. Next slide, please. So in addition to the social movement, we feel that the judicial system is very important, because without the judicial system, through the adversarial system, will bring out an actual dialogue. You have to state your case. And what normally happens in society is, even if you want to state your case, the other party will not state their case. And so people cannot judge what is the right thing to do. But the judiciary system helps raise that. Next slide, please. So in 2019, 5 litigation was strategically started all over Japan, in the 5 cities of Japan. That was in 2019, in February, and already 2 courts have rendered their judgment. Next slide, please. The first judgment declared that not recognizing marriage for same-sex couples was unconstitutional. And that was a great win. We didn't expect it, but that sparked further conversation and dialogue and from the legislative move. Next slide, please. I'm running out of time, I know. And the next judgment, unfortunately, was rendered unconstitutional. But the good thing was that at least it sent a message of the pain and suffering of the LGBTQ people and asked the judiciary, asked the legislature to act on this. Next slide, please. And what was significant was that the viewpoint activity was actually recognized by the courts. And we found out that the judiciary listens to what happens in society, and that if businesses raises their voice, then there will be recognition, and that should be a spark to the next movement. Yes. And so we continue to work on this, and I think I've run out of time, and I thank you for your attention.
Thank you so much, Fujita-san. Thank you for sharing. It really sounds like the key to a lot of the work you do is to encourage conversation, and that includes using the judicial process to create a cultural shift. And I think that's a very innovative way of looking at it. I understand you may have to leave pretty quickly, so if there are any questions for Fujita-san, what I would offer to do is you can perhaps come to me, and I'll give you my name card, and you can write to me. And if Fujita-san is agreeable, I'll send the questions over and have him respond in that way. So I'd like to move on now to our other panelists. Perhaps Pak Teo, would you like to introduce yourself, your organization in a little bit more detail? And let us know, based on your research in Indonesia, who is the most underrepresented group in the country in terms of access to justice, and what are their main challenges?
Okay, thank you very much. First of all, I would like to introduce myself. My name is Diwasar. I'm working in Indonesia Judicial Research Society. My organization focus about the Indonesian judicial reform and the access to justice. Maybe I would like to present about our experience when we were developing Indonesian access to justice in 2019. Indonesia IJRS, in collaboration with the Indonesian National Ministry of Planning and other CSOs like Indonesia Legal Aid Foundation and Indonesia Legal Roundtable, we were developing access to justice index because we would like to know about how the implementation of access to justice and how the understanding about the people or the community about the access to justice itself. And we would like to, and we also input the legal needs survey perspective in our index, since we need to understand about how the capability of the people or community when they had a legal problem. And this is the framework of our index. The first one is legal framework, and the second one is the mechanism to resolve the legal problem and legal aid to quality of process, the result of process, and the last one is the legal capability of people. Maybe the next one. For our index, we would like to understand the lowest score is coming from the legal framework, because the problem is coming, there is like overlapping regulation in Indonesian law. So that's why it's very difficult to understanding about the substance of law, and sometimes there is a problem when they have to go to mechanism. It's difficult to understanding about the law, and even there is like the overlapping in the same regulation. Maybe for example, like the current issues like Indonesia like develop like restorative justice law in police and the prosecutor. But the problem in the police and the prosecutor, there is like a different scope of restorative justice and the scope understanding about the restorative justice. So it's very difficult if we are the people, we have to follow which one the regulation, and then maybe we can understand about the result of quality of process is very good score. But the problem, most of the people when they had a legal problem, they prefer to go to informal mechanism, because they are afraid if they go to the formal mechanism, the problem will be more complicated. So that's why they prefer to the mechanism that they are feel more comforting. Maybe I would like to explain more in the next slide. Maybe yes. Based on our findings, there is like 38% do nothing when they had legal problem, and more than 50% is coming from the woman, because because they are afraid if they go to the mechanism or legal mechanism, the problem is more complicated. Even when they do an act or do something, they prefer to, most of them they prefer to informal mechanism. So that's why the result is in the is very good because in the informal mechanism it's very easy to take a process. And maybe this the next one. Even when they had to go to the legal mechanism, most of them prefer do not use legal aid because they are afraid that process will be complicated if they're using the legal aid or lawyer, and then maybe because like they prefer to share the problem to the family or to the prominent people in the community because they already know their people, so they are comfort to talk their problem rather than go to the lawyer. So this is also the challenging to give the socialization or understanding about how the important legal aid, how important the lawyer. So that's why most of them when they go to the formal mechanism, they have a complicated or they have a difficulties access because they didn't understand the law and they didn't have a lawyer or some kind of like legal aid organization. And next one, maybe I would like to share about our current legal need survey, but is still unpublished research. But the research is most of the victim in the minorities group is coming from the poor people. So and the respondent from who coming from the poor people is involved with the legal problem with related to the economic case. So you can imagine, and most of them didn't have like the social aid from the government, like the insurance, health, like the social security. So that's why when they had to go legal problem, legal mechanism, there there is they are need for payment to the administrative or to for paying lawyer. So that's why the problem when they go to the legal mechanism or they had a legal problem, they are not they cannot move from the poor situation, poor economic situation. So that's why they are still in the under under economic standard in Indonesia. So that's why it's very important when we talk about the legal development. It's not talk about the how to reduce uh, the barriers in the judicial reform, but we also emphasize or also understanding about the vulnerability and especially for the guarantee or from the social security because in Indonesia has a mandatory to have like healthy insurance, public healthy insurance or social security, but the problem most of them is not cannot access to those insurance. So that's why it also can we can also understanding the root of the legal situation is coming from the poor or economic situation. Maybe that's it because the time is already limit. But the my recommendation, maybe the last one, the recommendation we have to give the pay attention or more funding to ensure the social security. And the second one, we have to improve our criminal procedure or our civil procedure to um, improve or to eliminate the barriers. So that's why the accountability or the transparent process people can access easily, and then the education to important have the lawyer or legal aid or to give or supporting the legal aid as free is very important because it can help the people when they have legal problem. Maybe that's it.
Thank you, Pak Dio. I think what I found most interesting in your presentation was the intersection between women and poverty, because those were the two main groups that you highlighted. And I think this is a nice segue perhaps to go to Ms. Ankana. You work a lot with religious minorities in Thailand, but you also work a lot with women, I understand. Would you like to share your perspective, please?
Thank you very much, Hannah, and thanks for having me today to join this event. I want to start that from my experience as a women human rights defenders. I'm working to support the victims of human rights violation in Thailand, the victim of enforced disappearances and tortures. And when I work with the victims, and I found that behind the victims, there's a lot of women that carried all the burden, and nobody like to pay any attention to women, because when the men were arrested, it's women who go to the police station, who go to the court, who go to the hospital, who go to the military barracks. So when most of women, you know that even though they fight for justice for their loved one, their husband, son, or father, but many of them still faces like domestic violence or sexual violence in the families. So I'm very interested on the women human rights, especially about the vulnerable groups. My first report on access to justice of Malay Muslim women in southern Thailand, I wrote it in, I think, 2008, and in 2012, I worked with the International Commission of Jurists on the report of access to justice of women in Thailand that explore a lot of problem of women human rights in the country. And it's opened my eyes that I have a good opportunity to work with all groups of people. For example, the refugee women, women with disabilities, the sex workers, and all the groups of vulnerable women. My experience, I engage with a lot of, I have experience of drafting many laws in Thailand. For example, the Constitutional Law in 2007, the Gender Equality Act 2015, and the Safe Abortion Act, the amendment of Safe Abortion Act 2021. But the challenges about the law is that when majority of the drafting, the member drafting committee are men, so it's quite difficult. It's quite difficult to how can we say, because they are gender blind, they don't understand about gender equality, no. So that I think this one of the biggest challenges. I want to focus about the some groups of women. For example, women in southern Thailand that majority they are Muslim. In South Thailand, we have the Islamic Family Law and Inheritance 1946. It's very, very old, and actually this law applies in 4 provinces in southern Thailand, but it only to manage about the marriage, divorce, and to manage the properties. But when women face the domestic violence and like sexual assaulted in the family, and when they complain to the police, most of the police say that this is a family matter. So the police send them to the Islamic Provincial Committee for reconcile. This is one thing that that's very concerned. That another thing is about the legal pluralism. I think that it's not only in southern Thailand, but in other part of the country as well. In the indigenous groups, that women, most women still process for marriage. The children, women and girls cannot access to education. They're forced to marry since they are very young. So this is one of the problems. Another thing is about the informal justice system. You know that in some part of the country, especially in South Thailand, we have the informal justice system that the Islamic leaders or maybe the community leaders, they can have the some regulation that if women not wearing the hijab, they can like cut their hair, for example. And I want to speak a bit about the challenges. Firstly, Thailand is very progressive on gender equality. We have the constitution that mentioned that men and women are equal. And in the constitution, guarantee about the gender responsive budgeting. But the problem is that if you look at the national budget proposals, you will see that no ministry have specific proposal on women. And Thailand have the Gender Equality Act 2015, but the Gender Equality Act still give room for discrimination. For example, in Article 17, paragraph 2, it can discriminate regarding to religious reason, regarding to national security. And for religion reason, this make that the female monk in Thailand, the female monk, they cannot ordain in Thailand. But they have to ordain in Sri Lanka, for example, because Thailand not accepted the female monk. My second thing of the challenges I want to mention about the witness protection. When we talk about judicial independence.
Sorry, we're running out of time. Could you summarize your challenges very quickly?
Yeah.
Thank you.
Yep, thank you. When we talk about the judicial independence, but you know that many of the victims, when they face the threat or intimidation, many victims withdraw the case from the court. So I think that's the weakness of witness protection is one thing that's very important. Another thing I want to talk about is about judicial harassment. Now, when the people come, especially it's happened to women human rights defenders, that many of them faces the judicial harassment, especially some company can suing the women human rights defenders that make women very busy and like some of them face the online bullying also, and many of them affected by post-traumatic stress disorder. One last thing I want to mention about the barriers. For example, the languages that many, in Thailand they have some group of people that not speak Thai, so it's one of the barriers. And also money. We talk about the pro bono lawyer, but actually it's nothing free. So we have to look for funding. And lastly, the knowledge. If women have no knowledge, so it's one of the obstacles for them to access to justice. I thank you.
Thank you, Ms. Ankana. It sounds like a lot of the issues that are raised are definitely beyond the law and the legal system itself, and also even beyond legal training. A lot of it is very systemic and cultural and structural. So perhaps, AJ, would you like to build on that? Like, who are the underrepresented in your communities that you see?
It's an honor to me to be here and a great opportunity to share from the Nepal. So this is Ajay Shankar Jha. I am the Executive Director with the Public Defender Society of Nepal. We are the sister organization of the International Legal Foundation, which is based in the USA. The ILF, just a minor introduction, the ILF was established or founded 20 years ago to address the global crisis in access to legal aid. Every day, millions of men, women, and children are held in jails around the world because they cannot afford the lawyer to defend them. The ILF mission is to make justice a reality by fighting to guarantee high-quality legal representation for everyone arrested or detained. In 2008, the ILF set up first legal aid office in Nepal, dedicated solely to defending who were accused. I led those legal aid offices case by case. We worked not just to transform our clients' lives, but ensure the law was written, was realized in practice by litigating rights violation all the way to the Supreme Court. with the goal to be locally led and sustainable. In 2017, I left Nepal project, spun off into the Nepal, all Nepal-led organization, the Public Defender Society of Nepal. With over a decade of experience defending indigent accused in courts throughout Nepal, the data we have collected shows that there are extensive discrimination based on the caste, ethnicity, religion, and of indigenous community in Nepal's justice system. Approximately 70% of PDS Nepal clients are from marginalized groups such as Dalit, indigenous Janjati, ethnic Madhesis, and Muslim minorities who are socially, economically, politically backed to services. The main challenge we see is that Nepal justice system is criminalizing poverty and status. People are being locked up not for what they are done, but because of who they are. Two issues we are currently litigating this point. Law enforcement in Nepal uses law related to public interest, safety, and morals to extend social control over marginalized communities, particularly members of low castes and indigenous community. This law is often used to drive marginalized population out of public spaces where they have a right to be and into crowded jails and prisons. Nepal is routinely jailing the people and marginalized for non-payment of the court-imposed fine and fees without finding to ability to pay. Here I want to share, I have time. Recently we have conducted a research. I led research project in which we are able to survey every child in detention in 8 correction homes across Nepal. The statistics dissipated the discriminatory impact of our criminal justice system was alarming. 78% of the children in detention belong to marginalized ethical and religious community. The statistics also shows that most of the children did not have access to quality legal representation. Over the 1,500 children interviewed, only 63% indicated that they are represented by a lawyer. About 18%, 18% stated that they had no lawyer. And almost 19% indicated that they had no idea whether they were represented by a lawyer. And the failure to provide access to legal aid didn't impact the children equally. Female children and marginalized ethical minorities were less likely to be represented by a lawyer. Other critical findings of this research indicated that without access to a lawyer, specialized and knowledgeable about defending criminal accused of criminal offenses, their rights were more likely to be violated. They were more likely to be arbitrarily or illegally detained and wrongfully convicted or sentenced. Often judges were not aware or misinformed about the relevant laws they should be applying. And in other cases, children were being illegally detained, for example, for failure to pay a fine through they had no ability to pay. And I am going to stop here to be here with the time. Maybe I will follow the other question.
Thank you, AJ. Thank you for sharing. We are running short of time, so I would like to turn the floor over to the audience. If any of you have any questions, I think we might have time for 2. If anyone has any questions, please feel free to raise your hand. If not, because I do want to make use of the fact that we have 3 specialists here, I do want to ask a couple more questions, specifically relating to some of your strategies and approaches that you've adopted in order to support the people that you work with. So perhaps you could share a little bit about the tools that you have adopted and what specific learnings you think can be transferred to other situations and other contexts. Which one of you would like to go first? Do you have anything off the top of your head?
So maybe I will take the opportunity. a big step towards improved access to justice for poor, vulnerable, and marginalized communities who are disproportionately affected in the criminal justice system would be to ensure that the right to legal aid enshrined in the Nepal Constitution and protected under the fundamental human rights to a fair trial is upheld. This means not only ensuring that a lawyer is provided to every person in every case, but ensuring that the lawyer is qualified and has resources to provide a meaningful defense and challenge illegal actions and discrimination by authorities. We also have to get serious as advocates about challenging discrimination in all its forms. To that, to do that, we have created an action plan that focus on many different strategies, include litigation, policy advocacy, citizen engagement, and people-led movement for reform. This should be a cross-border movement in which we can learn from each other about successful strategy. Earlier this year, I joined the global campaign to discrimination, poverty, and status, and at their annual convening in South Africa in September, I was also able to meet other advocates through South Asia fighting similar challenges. As we are in Nepal, I proposed that we established a regional network to support and assist each other to challenge discriminatory law and participate in our countries as organizations in Africa have successfully been doing for the years.
Thank you, AJ. So it sounds like forming networks and working together is an effective tool that you have identified. Ms. Ankana, do you have anything to add to that?
Actually, for me, I think that firstly, for the tool, I didn't think about the high technology because when we talk about vulnerable groups of people, some of them not have the smartphone, so I think that is quite difficult. For me, I think firstly, I want to mention about the empowerment. The empowerment is not only to victims, but also the state official. And I think one thing that's very important is about the human rights education that is have to start since the young generation at school. I think that the kids and the children in school should start to learn about gender equality since they are young at the school. Secondly, I want to stress about the inclusive society. I think this is very important. When we said that we have really progressive, we have democracy, but actually, you know that in the movement, there's men and women. But when we selected somebody to be engaged in the policy making or the whatever, most of the people that engage in the policy making, they are men, but only few women that can engage to the policy making. And thirdly, I have some recommendations. I think that all countries in Asia should follow the recommendations. For example, the UPR recommendations. I think that all countries have the UPR recommendation, but mostly not implemented. And many countries, maybe all countries, ratify the UN conventions. For example, the Convention on the Rights of Disability Person. I think that if follow the recommendation of the UN committee in all of the convention and the UPR, I think is one thing that it should solve the problem.
Thank you. So representation is key, and also identifying best practices that have already sort of been articulated, for example, by the UN, and seeing how that can apply in your local context. Pak Dio?
I would like to respond. The first one, maybe when we talk about the implementation access to justice, to measure the access to justice, we have to understand according to the justice need. designated by the people. We have to identify the barriers and the problem of the people. And the second one, when we talk about the rule of law and access to justice, the advocacy by the community and or the TSO should be to encourage to reduce the power of the government, especially in the legal officer. So that's why when we have to shifting the power of the legal officer into the ensure the transparency and accountability. So that's why when we give a training to the legal officer, or we have to strengthening the law or the institution, is the goal is to ensure to the access to justice and the needs of the people, not to give a really power to them. So that's why it can impress to the people, especially for the minorities.
Thank you, Pak Teo. So it's really about understanding the justice needs of the people that you work with. And I think we heard a little bit about that from Doreen's presentation on identifying what the needs might be. Okay, we've got 2 minutes left. Does anybody in this room have a question? Yes, I see a hand raised over there. Unfortunately, we only have time for one, so over to you. Behind, at the back. Turn around.
Thank you. Ethan Hisakshin from the Transitional Justice Working Group in South Korea. First of all, thank you very much for your presentations. It was really really encouraging to hear how you, in your respective countries, try to advance the cause of justice, access for the various minorities. So this is something that I guess like Ms. Ankanya kind of mentioned already, but in your line of work, have you engaged with the UN mechanisms to further your objectives or goals in furthering the justice access? Thank you.
Okay, so very quickly, have you adopted the UN mechanisms, made reference to the UN mechanisms?
Yes, in any ways, like UPR, special procedures, treaty bodies, whatnot. Thank you.
Would you like to answer that?
I think everybody should know that all countries ratifies a lot of UN convention. And for the universal periodic reviews, is one of the tools that the United Nations believe that is the effective mechanism, because all nations adopted the recommendation, is volunteer adopted. So if state volunteer to adopt, it must implemented all the recommendations that were adopted. I think this is very important, but the problem is that many people in that state not know about the recommendations. So I think that you should follow. You can click in the search in the Google your country, and you search about the UPR, Indonesia, UPR, Nepal, and then you will receive that the information that how many recommendations that your country adopted. So you should use this to ask your government how they implement it. Yeah, and I think this is one thing that very good mechanism.
Okay, thank you, Ms. Ankana. AJ and Pak Teo, would you like to just say a couple of words to add to that?
Yeah. In Nepal, we do have all instruments in the place, like we rectified CRC, ICCPR, all treaties, the UN, and we needed to submit periodical reports to the UN agencies. Even there is, and we are celebrating, I mean, as a UN members, we are celebrating 10 years of the principle and guidelines to the legal aid in criminal justice system, which was adopted 10 years, I think in this month, 10 years before by the 11th Assembly of the UN. Though this is in the place, but the government willingness and the priority is the difference. So the government's priority is not in the legal aid in the priority. We have some sort of legal aid scheme, but they are lack of efficiency, they are lack of the training, they are lack of the budget and resources. So they be not able to perform the duties as per the need.
Thank you very much, AJ. Pak Teo, you okay? Or?
Maybe I think for Indonesia, for the to implementation, I think there is like some convention, maybe similar with the other countries as well, like SSPR, ECOSOC, and for disability convention. I think, but the problem is when we ratificate like some international standard, but the problem is how to ensure to the implementation regulation or the technical regulation by the government to compatible with the international standard. But sometimes the problem maybe that there is some like regulation maybe is not compatible with the regulation.
So it's an ongoing discussion. Okay, sure, Ms. Angana.
I want to speak more about the special rapporteur or special procedures and the UN expert, the working group. They are all the experts and they are independent. They not work as the staff of the UN and they not get any salary from the UN. So you can write to them. As Margaret said at the opening remark about she's a rapporteur on independent judiciary. So you can write to them directly through all of the special procedure. And they can communicate to your government. It's like a bridge to convey your complaint to your respective country.
Okay.
Yep. And they will let you know. Yep.
Thank you. Thank you so much, Ms. Angana. And with that, I'd like to thank our panelists for joining us today. And I believe I'd like to hand the time over back to our MC. Thank you.
Thank you so much, Ms. Hannah Lim, as our lead moderator for the last session of the interactive sessions. To the panelists, we would like to ask for your keenness to kindly return to your seat. Thank you so much. One more greatest applause, ladies and gentlemen. Distinguished guests, ladies and gentlemen, before we are with the closure of today's first day forum, I would like to inform you a few announcements for those who are invited to attend the working meeting with the WJP partners, the partnership for the WJP. Please kindly, after this forum ended on the first day, proceed to the Jaya Room. Second announcement. Tomorrow, we're going to start the second day of the forum. It will start at 9:30 a.m. sharp. So make sure that everyone arrive before 9:30 to conduct the registrations again. Ladies and gentlemen, the third announcement. Please kindly keen to return the SIS receiver or the interpretation device to the registration desk located at the foyer area. Ladies and gentlemen, we also would like to announce that dinner will be served at 7 p.m. tonight in the Istana Ballroom. Bapak Ibu sekalian, ini ada beberapa pengumuman. Jangan lupa untuk mengembalikan alat penerjemahan kembali ke meja registrasi yang ada di area foyer di depan Istana Ballroom. Lalu juga makan malam disediakan pada jam 7 malam ini di area Istana Ballroom. Ladies and gentlemen, thank you so much. We would like to address our highest gratitude for your presence and also attentions and participating on the first day of Asia Pacific Justice Forum, Building Partnership for the Rule of Law. Please give the greatest applause for everybody. Please be careful with your belongings and see you tomorrow at the second day of the forum. Wassalamualaikum warahmatullahi wabarakatuh. Melati Dewi sign out of the day. Thank you so much. I'll see you tomorrow. Greatest applause one more time, ladies and gentlemen. Give the spirit. Thank you. Bapak dan Ibu sekalian, mohon dicek kembali barang bawaan Anda. Pastikan jangan ada yang tertinggal di area ballroom. Ladies